Hey, everybody. A little bit early. Matthew, if you're still here, I'll talk to you later, I'm sure. Kat, if you're still here, I can't believe you read 9,000 pages of that motion. Hey, Aaron. I just realized I had my YouTube open and I was wondering why I couldn't change stuff in my video, but it's just the video. Okay. All right. Hey, Trakisha. Ooh, I still need to do that New Jersey case. That one with the lyrics. That reminds me. I gotta add that to my list. So, this stream is mostly going to be about Rice Street. At the end, I'm probably going to talk about Raven Liberty because I can't help myself. She really outdid herself very recently. In this new case, actually, not a new case at all. It's from 2020, but it's going to go to trial relatively soon. 2020 homicide, double homicide. It's wild. I was tweeting about it last week or this week. I don't remember. Okay, I guess we get some people here now. So the first thing I wanted to show was this clip from the YSL trial. Some of you may remember. This one right here. Oh man, I hope this works. This is Rudy. He's going to be testifying about Rice Street, which is the subject of this video. That on my window. And I'm just going to play that to start. I think. Okay, here we go.
Mr. Copeland, with your background and your experiences in jail, is it fair to say that you would do anything not to go to jail?
Okay, I may have started at a Woody's overly long pause that goes for another 30 seconds.
Mr. Copeland, can I ask you a couple of questions?
I'm listening.
Okay. For people who've never been to prison or jail, do you know the difference, by the way?
Y'all know the difference.
Objection on relevance. Sustained.
Whether it's a prison or jail, is it fair to say that
Rice Street is not either one. There's not prison or jail. I don't know what that place is. This is the worst place in the world.
do you remember?
So, there are a lot of times Rudy talked about Rice Street, but I just picked that one because you can kind of see the reaction that he gives when Rice Street is brought up. But here we go. So, okay, so for the Wolfenbarger case, this is actually a funny coincidence. But this DOJ report on the Rice Street jail actually came out the week that Wolfenbarger was arrested. So if you're a Wolfenbarger person instead of a YSL person, this is the situation that he would have been dropped into. 9-3 is a chat holiday. I'm down with that. You know, tomorrow is the 1-year anniversary of Moonsunk beginning his testimony. It was day 122, I think, the YSL trial. I need to find out what day Brian Steele was. Brian Steele was locked up. That should be a holiday, not to celebrate, of course. Anyway, so the DOJ did a investigation of Rice Street. This was after the death. Well, you'll see, but there was a death that got some attention in Rice Street, and the DOJ did an investigation. You can see it published their findings in 24, almost a year ago. And we're just going to go through this. I'm going to skip some parts that are more, I don't know, like background that aren't necessarily relevant to the point that we're going to get into, which is mainly how Rice Street Jail impacts prosecutions and how it enables this DA's office to pursue prosecutions that would otherwise not be viable. So I'm not going to read all 100 plus pages of this, but let's just get started. I should do that, Aaron. I actually have, there are a couple of specific cases that I'm going to bring up after I get through this one. There was a case where there's I think he was like 20 or 19, and he was held on Rice Street for 4 years, and he eventually pled guilty just because he was tired of waiting. But, okay. So, okay, yeah, I should also say at the front, this is going to be, kind of a disturbing topic. So, if you're squeamish or what have you, you might want to, consider, I don't know, not watching, or I don't know, just fair warning. So, okay. So in September of 2022, LaShawn Thompson died alone in a filthy cell in the mental health unit of the Fulton County Jail. Mr. Thompson, who had a history of mental illness and was unhoused, was accused of spitting at a Georgia Tech police officer and arrested on a simple battery charge, then held on an old warrant. 3 months after his arrest, Mr. Thompson was found in his cell, slumped over with his head on his toilet. A medical examiner reported that his malnourished body was infested with an enormous presence of body lice and concluded that he was neglected to death. There was widespread reporting and outrage about the conditions that led to Mr. Thompson's death, but there was another death on the mental health unit several months before Mr. Thompson's that never made the news. An unhoused man with serious mental illness was arrested and held in Fulton County Jail's mental health unit after breaking into a building to seek shelter. On the mental health unit, he stopped taking his medications and his health declined. He was found unresponsive following a likely seizure and was transported to a hospital for care but never recovered. He died a month later. 2 more people died in the jail's mental health unit in the weeks following Mr. Thompson's death. Both men had serious mental health needs. One had a developmental disability. Both were killed by their cellmates, and both were found with their feet bound. One of them was wrapped up in bedding like a mummy. Altogether, these 4 black men with serious mental health needs died in the jail's mental health unit in under a year. Yeah, Lexi says it was sad. I remember reading this. Yeah, I was going to do something. I've been putting up doing this just because it's so, I don't know, it is so serious, and it's not really light reading. But after the Wolfenbarger case, I decided to, just because you can't really understand Fulton County without understanding Rice Street. They opened their investigation in July of 23, pursuant to these various statutes. Within weeks of opening the investigation, 6 more black men had died in the jail. One person was found unresponsive in his cell after his cellmate strangled him. And days later, tensions in the jail erupted in violence. Within 24 hours, 5 units in the jail saw violent assaults. At least 7 people were stabbed and 1 person was killed. After an extensive investigation, we find reasonable cause to believe that Fulton County and the Sheriff's Office violate the constitutional and statutory rights of people incarcerated in the Fulton Jail. Fulton Jail fails to adequately protect incarcerated people from the substantial risk of serious harmful violence, including homicides and stabbings. These are just the summaries, so we're going to go through each of these in detail. So I'm going to skip past the executive summary. I think. I want to make sure I don't skip anything that will be context for later. Yeah. Fulton County is the largest county in Georgia, with more than 1 million people, just over 10% of Georgia's population. It includes most of the city of Atlanta, but not all of Atlanta, because Atlanta likes to be special and confusing, and sometimes, somebody commits a crime in one part of Atlanta, and then they drive to another part, and the district attorney's office forgets that there are multiple counties, and it becomes a whole thing. Sorry, that just touched on a sensitive subject for me. I was just triggered there. It's a whole jurisdictional thing. Anyway, Fulton County Jail is the secure detention facility for people awaiting resolution of criminal charges. Pat LaBash, the sheriff, he's in charge. There is a county commission that funds the jail, or more accurately, doesn't fund the jail. There's the main jail and 3 annexes. People spend long periods detained in the jail. According to an analysis commissioned by the county, nearly 1/4 of the population of the jail on January 20th, 2023, 873 people, had been held for over a year. We did our own analysis on a random day in March of 24 and found the average length. The average length was 279 days. And this is all pre-conviction. I know you guys know this, but just saying. I shouldn't say all, it's 90+% pre-conviction. We identified 245 people who had been in custody for 2 years or more, 14 people who had been in jail for over 5 years, and 1 person who had been there more than a decade. These lengthy periods of confinement are more consistent with time spent in prisons than in a jail meant for pretrial detention. If you didn't know, that's the difference between prisons and jails. Prisons are post-conviction, jails are just holding, temporary holding. Many people in the jail's population have repeat stays. In June of 23, 41% of the bookings were repeats. Black people are overrepresented. 91% of the population in jail is black compared to just 45% of Fulton County. 9% white, less than 1% other. Let's see. According to the sheriff, 62% of the people who enter the jail have mental health or substance use needs. 207 people had a serious mental illness. Now, this is actually something that I was looking at recently. Exacerbating challenges facing the population with mental illness, the demand for competency restoration services has outpaced the availability of such services in Georgia. When people charged with violent felonies are found incompetent, they are often held in jail for long periods, awaiting placement in a state-run hospital. Recently, there was a guy, the longest stay in the pretrial detention was I think it was 16 years or something like that. And he had spent about half that time. He was awaiting a competency restoration so he could stand trial. And I think he spent like eight or so years in the jail and the other half in some kind of care facility. It was at least 6 years in the jail. I can't remember how much was in the facility, but he was just adjudicated. So he's actually, there's a new longest tenured jail inmate. He's also a competency question. I think the 3 or 4 longest are all competency questions. Okay. So, because Georgia is one of only 4 states where the juvenile justice system's jurisdiction ends at 16, all 17-year-olds, regardless of offense, are charged as adults. 2. Yeah, it looks like they're legislating maybe bringing it to 18. Along with 17-year-olds who have been charged as adults at 17, the jail houses 17-year-olds who, because of the nature of their charge or court order, were charged as adults at 16 or younger. These children are moved to the jail when they turn 17. In March of 24, there were 37 17-year-old boys and 1 17-year-old girl. The average stay for people who enter the jail at 17 is 392 days. That is a long time. Especially at that age. If you're in your 30s or 40s, 392 days is still a long time. But when you're 17, it's even longer. Jail has struggled to address a ballooning population and overcrowding. Sheriff reported that there were 366 people sleeping in temporary beds on the floor of the jail. So they're not even in cells. And, obviously you want people to have beds, but there's also a security concern there because people aren't locked up. And as we'll get to this later, but a big part of the security isn't locking people in so they stay in, but locking people inside of a jail cell so they can't be accessed by other people. So people sleeping on the floor are both vulnerable and they have more access to other people. So it's just a massive security problem. In July 22, the population was almost 3,400, an increase of 600 from the year before. Fulton County Commissioner described the overcrowding as inhumane. In an attempt to address the overcrowding, the county sought to speed up cases in the criminal courts, including by adding new judges and expanding remote access. This was the ORCA program. Some of you may remember Project ORCA, whatever it was. The sheriff's office also created its own program called the Inmate Advocacy Unit to identify people in the jail who need their criminal cases expedited. That's everybody. Or who could be appropriately released. You're supposed to do that anyway. Okay. According to that's just how the Constitution works. According to the sheriff, they want bonus points for doing the bare minimum. According to sheriff, as of September, the Inmate Advocacy Unit has secured the release. You can just release them. What do you mean secured the release? Fulton County and the sheriff's office have also transferred many detainees to other counties. I think it's Cobb, Gwinnett, one or two others. Over the past year, the population has declined. In mid-August of 24, the total jail population was about 1,800, and the main jail is at about 1,600. The main jail's population declining in part because housing units were uninhabitable. In August of 24, a presentation to the board showed that 630 beds were offline. 6 zones had sewage backups, 6 zones were undergoing repairs, and 6 zones were unavailable due to fire restoration. I don't think you want to restore the fire, but we'll let that one go. Or awaiting parts for repair of a critical safety feature, probably locks. The population will likely increase when these units reopen. That's the funny thing about jails and prisons. They always find a way to fill themselves. The jail is in crisis. I'm not going to go through this. This is stuff that was proposed that never happened. Funding increases. Exactly. In November 23, reports surfaced about misuse of the jail's inmate welfare fund. The fund comes from money incarcerated people and their families spend on phone calls and commissary items, and by county law was to be used for the welfare of the incarcerated population. Instead, money intended to benefit the incarcerated population went to staff benefits, e.g. honey-baked ham gift cards and a I'm sorry. This is the shadiest thing I've read. E.g. honey-baked ham gift cards and a bounce house rental, community events, vehicles, and tasers. Okay, I actually don't know that tasers are staff benefit. That's just equipment. But the bounce house is, that looks bad. In response, the board abolished the inmate welfare fund. That's not a good solution. And the sheriff's office lost direct access to millions of dollars that had been reserved for the incarcerated population's benefit. I want to know where that money went, though. It's not like the money stopped flowing. It's just not going to the, we'll get there. Deaths and serious injuries remain prevalent. Thus far in 2024, so through November, 3 men have died, one of a suspected drug overdose, one by stabbing, and one by suicide. Just detailing the investigation, the statutory authority. They were examining living conditions, protection from harm, use of force, medical and mental health care, and discrimination under various statutes. They observed board meetings. They interviewed staff. The expert consultants were brought in to analyze the jail, to the extent you can call it a jail. That decades of experience. We thank Fulton County for their cooperation. Jail facilities. The main jail was built in 1989, originally designed to house up to 1,125 people. The facility began double selling people almost immediately after its opening and now has 2,200 beds. First time I read that, I was convinced it said double ceiling, and I had no idea what it meant. So 2,200 beds, but remember earlier we said the population was like over 3,000. Most recent staffing analysis found that the most the jail could accommodate based on its operations was 1,800 people. In July of 23, there were 2,600 plus. But in mid-August, with multiple housing areas offline, the population was 1,500. Main jail is the main jail. It has an intake unit and a medical unit with medical and psychiatric observation housing for men and women. 17-year-old girls in the sheriff's custody reside in the women's medical unit. No comment on the 17-year-old boys. The main jail consists of a 3-story low-rise structure joined to an elevator tower, providing access to 2 housing towers. The north tower has 7 floors, south tower has 6. Each housing unit has 8 zones arranged in a horseshoe around an elevated control tower. The housing zones have between 16 and 18 cells, split over 2 tiers. The cells open to a day room with tables bolted to the floor, phones, a kiosk for ordering commissary and submitting grievances. We'll get to that. And a shower on each tier. These are the other annex jails for segregation or particularly violent inmates. Civil rights violations identified. Yeah, now that you guys mentioned it, I do remember Cat Stream on this. I remember the honey baked ham, now that you mention it. So, protection from harm. Fulton County Jail does not adequately protect incarcerated people from a substantial risk of serious harm from violence inside its facilities. Violent acts against other incarcerated people include homicides, stabbings, and sexual abuse. People with serious mental illness, people identified as gay or transgender, and young people are particularly vulnerable to violence. Poor supervision, classification, jail maintenance, and contraband control and investigations contribute to the unacceptable violence. Correctional officers have a duty to, just reading the lie here, correctional officials have a duty to protect prisoners from violence at the hands of other prisoners. Jail officials violate the 8th and 14th Amendment rights of those in their custody when they are deliberately indifferent to an excessive risk of violence. Occasional isolated attacks by one prisoner on another may not constitute cruel and unusual punishment, but confinement in a prison where violence and terror reign is actionable. Deliberate indifference may be established where serious inmate-on-inmate violence is the norm or something close to it. Failure to separate violent from nonviolent people can amount to deliberate indifference, create an excessive risk of violence. The failure to adequately supervise and monitor incarcerated people, provide sufficient staffing, confiscate dangerous contraband, and investigate misconduct may also constitute deliberate indifference and expose incarcerated people to substantial risk. This is also a shady paragraph. Leadership at the county and sheriff's office are aware of the violence in the jail and have publicly decried it. Yet they have failed to take adequate action to address the crisis, and homicides, stabbings, and other violent acts continue at dangerous levels. Okay. Before I get into this part, I want to show a video that I pulled us from the YSL trial. This one will be the attack, specifically how long that these guys over a little bit are proceeding in their attack without being interrupted. We're not going to watch the whole thing because it's like 20 minutes, but you see that it starts at 6:47. We're watching Adam Abate's screen. So yeah, this is YFN Lucci, Rayshawn Bennett. So there are people just kind of wandering around. They're pausing it. This is testimony. I didn't want to listen to it. But they're wandering around 6:47, 6:57. Whoa, not.
After Friday, June.
Sorry, I switched to Woody's again on my screen. 6:58, where you have here. So, see here, they're just walking around. Let's see, I believe the attack started around 7:02. You see here, they're trying to access the cell, which should be locked and inaccessible. So here they're starting to get into the cell. Again, no response. I think the guards are about to show up very hastily. So the attack went on for, I believe, almost 2 minutes before it was broken up, and the attackers were just wandering on the jail floor for roughly 20 minutes, maybe 15 minutes beforehand. So both access and the response were, I mean, there was no response. And I don't know if we get to it today, but I have a bunch of reports from various fights. A lot of them are from Shannon Stillwell's class action and some of the other YSL related case files. But there's no shortage of these. Okay. In less than 24 hours, yeah, factual. The way he just strolls over. Killings, stabbings, and assaults are common in the jail. In less than 24 hours in August 2023, at least 7 people were stabbed and 1 was killed. Violence spanned 5 units and 3 floors. It started at 11:30 p.m. when officers discovered that people from one housing zone had opened their zone door, not their cell door, the zone door, and entered another. Do I know who? I think I know what case this is from. Is this from? No, this was May of 2023. This was a different riot. My bad. The fact that they described an interzone brawl, and I had the wrong one. No, that's what I was thinking, Aaron. That's what this is from. But this was from May. We were on the same page. It started 11:30 when officers discovered that people from one housing zone had opened their zone door and entered another zone to assault people. The next day at 2:21, an officer heard screaming coming from a restrictive housing unit on the 7th floor. He found one incarcerated person with blood on his shoulder and a second incarcerated person on the floor in a pool of blood. That person died from multiple stab wounds. The locking mechanism for the doors in that unit had been broken. And while officers tried to secure the scene, incarcerated people kept trying to assault each other. One incarcerated person had to be treated for exhaustion. Almost simultaneously, at 2:26, a sergeant found another incarcerated man with blood on his face and chest in another unit. The victim required emergency medical transport for multiple puncture wounds to his face and back following an attack. At 9:15, an officer tased someone to break up a fight. Medical attention for the taser deployment was delayed because the jail was overwhelmed with stretcher calls. From 2022 to the present, 6 incarcerated people have died in violent attacks. April 24, a 37-year-old man died after being assaulted by another incarcerated person. Medical staff found the victim lying at the entrance of the housing unit with multiple wounds and covered in blood. The victim was stabbed 20 times with a 9-inch weapon and sustained stab wounds to the head, neck, torso, arms, and legs. In August of 23, a 23-year-old man died when he was stabbed multiple times by one or more other incarcerated people, as described above. The victim was found lying face down on the floor of the day room. And again, that's just the open area in the jail, so it should have been visible to the guards. In a pool of blood with deep lacerations to his upper back. He had stab wounds to his head, neck, abdomen, back, and arms. In August of 23, so that's the same month, a 34-year-old man died from strangulation. The victim was found unresponsive in his cell. November of 22, a 32-year-old man died in the mental health unit after his cellmate allegedly assaulted him. The victim's feet were bound, and he had a bloody nose and raccoon eyes. a sign of head trauma. Medical responders reported that his body was cold to the touch. So he was found well after he passed. You'll see that again later. Sorry, I just had to fix the setting there. In October 22, a 20-year-old man died in the mental health unit, after being strangled by his cellmate. The victim was found wrapped in a county-issued blanket with straps tied around his ankles, knees, waist, chest, and neck. In September of 22, a 33-year-old man died after being stabbed by another incarcerated person. The victim had a stab wound between his shoulder and neck and a deep gaping wound above his eyebrow. A significant percentage of the homicide victims had one or more serious mental illnesses. All had been incarcerated for months or years. Their average length of stay was 253 days. The longest was 654 days. All 6 victims were black men. Half of the homicides involved sharpened weapons. Read this excerpt here. I had knives put to my throat, and I had to call my mom telling them, please wire somebody some money or I'm going to be killed. Nobody should be subject to that at a jail where you're supposed to be waiting to get your day in court. Assaults and stabbings with man-made shanks are a feature of life at the jail. In May of 24, 4 incarcerated people entered another man's cell and stabbed him 8 times in his sleep. Days before the April 24 stabbing death, another incarcerated man was stabbed in the head and did not seek medical treatment for 10 hours because of ongoing threats on his life. One of the 2023 homicide victims was injured in 3 previous stabbings at the jail. According to the Sheriff's Office reports, in 2023, there were 1,054 assaults on incarcerated people and 314 stabbings. In 2023, the rate of stabbings at Rice Street was 1.5 times the rate of stabbings in the New York City jails, Rikers Island, and more than 27 times the rate of all incidents involving an edged weapon in the Miami-Dade County Jail. The jails had as many stabbings in a single month as the Miami-Dade County jails, which house 1.5 times the people, had all year. Rate of stabbings, 10,000 per 100,000 people. That's insane. We also analyzed violence in the jail by examining violent incidents in these same 2 months in consecutive years. More people were injured during February and August of 23 than in 22. Violence in the jail appears to have increased from 22 to 23. And from February to August, the amount of violence remained high, even as the population declined. Yeah, see, the population in August of 23 is significantly lower than in 22. The violence is still significantly greater. In the first 9 months of 23, there were over 200 emergency transports of incarcerated people to an outside hospital for injuries from assaults. In one case in August 23, medical staff at the jail treated an incarcerated person after several other incarcerated people reportedly stabbed him in the face and beat him. He reported pain and difficulty breathing, and medical staff sent him to the hospital for a possible rib fracture. Not for the stabbings, I guess. In July of 23, an incarcerated person was sent to the hospital after another assault. He had 9 total stab wounds and required care for complex lacerations and to rule out a tendon injury in his hand. In May of 23, an incarcerated person was sent to the hospital for injuries to his scalp, chest, arm, thigh, back, and hand. His assailant used a 16-inch shank in the attack. That is damn near a sword. I don't even think you can call that a shank anymore. Spear, maybe? There were more emergency medical transports from the jail for injuries from assaults over this 9-month period than there were in all of 22. So again, significant increase. In some cases, officers have allowed, this is crazy. In some cases, officers have allowed or initiated violence at the jail. In February of 23, a detention officer opened a door to let an incarcerated person leave his assigned housing zone and enter another housing zone, where he and multiple others attacked someone. Though the officer witnessed the assault, she did not report it or get medical help for the victim, and she later sprayed cleaning solution on the blood. The officer was terminated and criminally charged. April of 22, a jail deputy was fired after he opened an incarcerated person's cell, brought him to another person's cell, then stood by and watched as the two men fought. Big Library says Fulton County needs to build a new jail, but they don't want to upset North Fulton because that's where a lot of the tax money comes from. Yeah, that makes sense. Everyone acknowledges that there was a problem, but nobody wants to pay for it. When a federal court ended a prior consent decree, so this is the second time the Department of Justice has stepped in. The Sheriff's Department had reported 2 physical assaults with a weapon in the jail in January 15 and 3 such assaults in December 14. By comparison, there were 7 stabbing incidents in January of 24 and 10 in December of 23. Over 3 times the reported number of assaults with any type of weapon at the end of the court's oversight. So basically, they were let off of probation in 2015, but they didn't learn their lesson, so they had to go. DOJ is saying it's time to put them back under supervision. There's also reason to believe that the sheriff's office data does not capture the true extent of the violence inside the jail. Not all violent incidents are reported and documented. For example, in September of 23, we advised counsel of the sheriff's office of a report that an incarcerated person had been stabbed the week before and required medical attention. In response, the jail's medical staff met with this person and confirmed that he had multiple stab wounds to his chest, back, and hands. No incident report documents this assault, and the person told medical staff that although he reported the stabbing to an officer, he was not taken to medical for treatment until we alerted counsel of this incident. We also identified instances of incarcerated people transported to an outside hospital for injuries consistent with violent assaults without incident reports documenting what had occurred. So it's even worse than everything we just read. Low staffing levels in the jail, will be described later, contribute to the failure to report many violent incidents. Another factor is victims' fear of retaliation for disclosing violence. In March of 24, a victim suffered through the night until the next morning because he was afraid to report that he had been stabbed. Although this victim ultimately reported the assault, he refused to identify the assailants, saying that doing so would put him in danger anywhere in the jail. In a separate incident that month, an incarcerated man with multiple puncture wounds to his back and arm denied having been assaulted, insisting he fell out of the bed. I think he probably wasn't injured falling out of the bed. Jail fails to protect vulnerable populations. People with serious mental illness, people identified as gay or trans, and younger people with less experience in the jail system are particularly vulnerable. As mentioned, 2 people with serious mental health illness were killed by cellmates in the jail's mental health unit in the fall of 22. One of the victims had an intellectual disability. In February of 23, 5 serious assaults occurred against people in the mental health unit by their cellmates. Again, this is in the mental health unit, so they should be subject to heightened supervision, you would think. In some cases, people perceived as mentally ill or who act strangely are forced out of housing areas by other incarcerated people. In April of 23, an incarcerated person reported that he feared for his life because he heard people in the zone announce these mental health folks going on the door tonight, and believed that he and others with mental health needs would be forced to leave the housing area. Which is crazy. It's essentially saying that the inmates run the prison. That's an idiom, but it's literally true here, it seems. Inmates should not be dictating where people are placed. People perceived to be gay or trans also have a high risk of experiencing violence. Identified multiple instances of incarcerated people being targeted for violence based on perceived sexual or gender identity. April of 24, an incarcerated person reported that another incarcerated person assaulted him because he was gay. Victim had visible scratch marks, bruises, and cuts from the assault. In October of 23, a person reported to officers that he was not safe because people in his housing area were accusing him of being gay. He was stabbed later that day after reporting it. That same month, a person who presents as trans, a trans woman, uses a female name, was stabbed while asleep on a temporary bed on the floor of a housing unit. That gets back to what I was saying earlier about the temporary beds. You're completely exposed. Not that you're not exposed in a cell that doesn't lock, but you get the idea. The victim told an investigating officer that the assailants targeted her because of her sexuality and that it was a hate crime. She shared with us that her assailants used various slurs while attacking her. In June of 23, an incarcerated person reported that multiple assailants attacked him in his sleep because of his sexuality, telling officers, "I am bi." He has gotten out, and now everyone is at my head. He said that he was moved after being assaulted on another floor for the same reason. The officer observed one of his fingers is broken, his elbow looks out of place, and he has several bruises on his face. Additionally, 17-year-old boys have a substantial risk of experiencing violence, particularly in the period shortly after their arrival. We identified a pattern of 17-year-olds initiating other newly admitted boys to the jail with violent assaults, including 5 cases where boys were seriously assaulted within 2 weeks of admission and required outside medical care for their injuries. Yeah, exactly, Chukisha. Like, if somebody opens the door, at least you'll wake up, right? Even if it's not locked. Maybe. And this part here, the 17-year-olds being initiated, if they're innocent, I mean, that's a really good way to get a 17-year-old to join a gang. If somebody's not in a gang, that's a really good advertisement to join a gang. Having somebody to band together with and for protection. In June of 23, a 17-year-old boy submitted a grievance saying he was not safe, as other 17-year-olds try to make every new person crash out, having people fight me and try to stab me. Despite only around 30 17-year-old boys living in the jail, they were assaulted and required off-site emergency medical care on multiple occasions, including in incidents in February, April, and June of 23, when 17-year-old boys were choked, stabbed, and beaten. September of 23, an incarcerated adult attacked a 17-year-old boy who was living in a unit with adult men, despite jail policy requiring separation of 17-year-olds from adult detainees. Yeah, exactly, Aaron. Aaron said, or an 11-year-old like Trontavious Stevens, aka Tick. During his trial testimony in the YSL case, he spoke about, essentially learning about gangs in jail because he was put into a juvenile detention facility when he was 11. And essentially thrown away by society. And then once he, overcame all of that and, became an ordinary, boring guy with a regular job, he was dragged back into the system by the YSL case. And then, he was thrown into this jail and then called to testify to get out of this jail. Funny how that works. There's a substantial risk that people incarcerated in Fulton County will experience sexual abuse. Poor supervision, poor classification practices, the proliferation of weapons, and poor conditions, including faulty door locks and lighting, contribute to an environment in which sexual assaults can and do readily occur. There is an inmate who was in Rice Street, I'm not going to use their name, who somebody was on a video call with this person, and it was pitch black, and it was like in the middle of the afternoon. You couldn't see anything. It was just dead black inside, no light at all. And this person the inmate seemed to think that it was completely normal. Let's think about how dangerous that is. Yeah, Aaron says, Tick lost his job because he missed too much work while testifying in trial. But to be fair, if he hadn't testified, we wouldn't know that Cleveland Avenue Park is located on Cleveland Avenue. So really, I mean, without that information, the whole case would have fallen apart. Tick is so funny, man. That might be my favorite moment from the entire trial. I'm going to pull that up later. Where is Cleveland Avenue Park located? She was just asking for it. I mean, really. Well, like, it was just a layup. Oh my goodness. I'm sorry, I shouldn't be laughing at this. I'm not going to read through this just because it's it's um, it's deeply disturbing. You can read it on your own. Basically, there are egregious amounts of sexual assault, sexual violence in the jail. Directed at, as always, directed at vulnerable people, particularly younger people. The reporting is wildly inadequate. I forgot that. Do you refer to Cleveland Avenue Park as anything else? Yes, the park. Just tip of the cap. I think that's one of the things that we saw come out of the trial was how smart a lot of these guys are. There's one inmate. There's an inmate. He is an inmate right now. One defendant whose name has been spelled incorrectly for decades. And he knows how to spell his name. He knows what his name is, but he knows that his name in the jail, like within the justice system in the area, is a different name. He actually knows to tell the police his fake name when they like approach him. He knows like the details of his second fake identity that the police invented just in case he's ever arrested. So he was like forced into adopting a double identity. And, you know, getting into Antonio Sledge, which I'm not going to talk about for, you know, until the state, at least until the state opposes. People like thought that he was dumb, when in reality he was the only one in the room who knew what was going on for extended periods of time. One thing I'll say is the plea agreement. You know what? Fuck it. We're doing it. We're doing a 5-minute tangent. I shouldn't do this, but I'm going to anyway. I'm going to tell you why Antonio Sledge knew within seconds that Adrian Love was about to lie to him. And he did know it immediately. I'm so mad about this. This is make it 2 and don't get in trouble. I'm not going to get in trouble. This is already, I'm just repeating something that's from the motion. So this is the plea agreement 1AS is what they called it during the trial. This is where these factual acknowledgments come from. I'm not going to mess myself up. I'm just repeating something that I wrote about in motion, or the brief. I've talked about this before too. I actually talked about this before I was even Antonio's counsel. So when Antonio was handed this, sentencing withheld until the completion of the trial of this case. Now, Antonio knew that he did have a sentence on count 30. So when he was handed this plea agreement, he knew it was wrong. And you can see right here, this is his old sentence that somebody got voided because they're very talented and handsome. You see that he has a sentence to serve on probation. So he knew that this plea agreement, which you may recall was the basis of him getting his probation revoked, he knew that this plea agreement wasn't the right plea agreement. And he was the only one present who knew that. But at the end of all that, people thought that he was dumb because he was confused as to the terms of his plea agreement. He said, I don't remember those plea agreements. Yes, I signed it, but I don't think that's the agreement. And he was mocked endlessly by the state and on social media for being dumb and for saying that, you know, the terms of the plea agreement aren't the terms of the plea agreement. And he was completely right. And he was the only one who knew that day in front of 400 lawyers, however many were in the room. He was the only one who knew. So my point is that a lot of these guys are quite smart, and I think Tick is one of them as well, who keep things close to the vest. And I think to survive and to make it out of that environment that they're in, and to change, it takes a lot of toughness and intelligence. Mary W says he was mocked so much on social media. I know. I've gone through and bookmarked everyone I could find so I can retweet them once I win. I'm gonna retweet hundreds of tweets as soon as he's out. I spent a long time doing that. I'm really looking forward to that, actually. Okay. Jumping back into something much less fun. Oh man, that reminds. I might maybe getting into a fight in Kat's YouTube comments because somebody called Antonio a liar in the comments, and I had to, the slander folder exactly. I do keep a folder filled with Antonio slanders and other slander against other people. You gotta go all the way when you do these things. Oh, okay. Now I'm going to awkwardly segue back to something that's much more serious. Actually, no. Let me take a second to say one more thing, just to contextualize this. The reason I'm reading this again is to keep in mind that people are, in many cases, getting out of entering agreements, either pleading guilty when maybe they're not guilty, to get out of this environment. They're agreeing to testify, to say whatever the state wants them to say to get out of this environment. And this jail is used as leverage to get people to do what the state wants. Twinks want to get home to his mom. He's managed to start a business and provide for 8 kids without a high school diploma. He's not an idiot by any standard. That's true. He did start a business. And his kids are doing extremely well, and they love him very much, and they miss him. Okay. We spoke with one man who was beaten and or stabbed in the head in a random attack while he was asleep in a boat, a temporary bed, in the day room of his housing unit. Again, you're completely exposed out there. He now has a metal plate in his head as a result of the attack. When we spoke to him, he had been in the jail for nearly 4 years. 4 years. He developed PTSD after the attack. He has trouble sleeping in the jail since his assault, has flashbacks, and has described jumping unintentionally when believing he may be attacked again. 4 years. I don't know how you're supposed to work on your PTSD when you're still in the middle of the traumatic situation. That's not even PTSD. It's not post. It's just traumatic stress disorder. There's no post about it. Our mental health expert identified another man as potentially having PTSD as a result of experiences in the jail. The man described being housed in a unit that people refer to as the Thunderdome. He recounted Thunderdome was right there. He recounted gang members taking him to a cell behind a staircase out of view of the security cameras and threatening him with a long piece of metal like a fire poker. He was then made to call his family and instruct them to send money via CashApp to another incarcerated person. And again, cell phones are everywhere, both in the jails and in the prisons. I mean, I've had inmates just DM me on Twitter questions about their case. I'm like, aren't you in prison right now? How are you DMing people? But I don't actually ask that because I don't want to know. But cell phones are everywhere. He also described a time when power went out in the unit and feeling that anything could happen to him in the dark. That's what I was talking about earlier. When our mental health expert spoke with this man, he described thinking about his experience often, having intrusive thoughts about it, nightmares, restlessness, and agitation, all of which are symptoms with TSD. Another person reported lasting effects from an assault inside his cell in which multiple people tried to steal his commissary. But a month later, an officer tased him after he refused to turn over a sharpened weapon that he had hidden in his pants. The person explained that he had stress after the assault and carried the weapon because he just wants to go home to his kids. Another person, speaking with mental health staff following a suicide attempt, said simply, "I'm tired of seeing people get stabbed." I'm going to skim through this part because I can tell you what it says. They don't keep gangs separated, and they don't reevaluate people after they come into the jail to see, if they're acting violently. The report suggests reclassifying people if they're involved in violence and, actively moving people around to minimize violence rather than just throwing people into whatever will be. Again, this is essentially what I was talking about. We found gang involvement in a significant amount of violence at the jail. In May of 24, 6 incarcerated people with gang affiliations entered someone's cell with knives and stole his commissary. September 23, 3 people were injured in a violent incident believed to be retaliation for a gang-related murder that had happened in the jail. August 23, 5 people with brooms and a man... I was going to say that, Cat. And a man-made knife attacked an incarcerated person, and the victim reported that this happened because he was no longer in a particular gang. So again, no longer in a gang. He was attacked for not being in a gang. That's what the jail does. And I imagine that guy really wants to get out and would probably, I don't want to speak for him, but if you want to get false testimony from somebody, that's how you do it. You want this guy to testify against the gang? Sign this piece of paper saying these things are true and we'll let you out. You don't have to worry about getting stabbed anymore. Their own negligence, it's not even negligence, their own neglect of the jail is an asset in prosecutions like this. That's kind of the point that I'm getting at. It plays directly into their hands. Despite the violence associated with gang activity, the jail fails to identify and track many gang-affiliated people in the jail. Without such identification tracking, the jail can't keep the gangs separate. In December of 2023, an incarcerated person reported that because he was not a gang member, he was told to pay $100 per day to stay in the housing zone. In October of 23, another person alerted officers that gang members were extorting him for protection money to live in the zone without being violently attacked. Again, the inmates are literally running the jail. In a separate incident, an incarcerated person was assaulted over a commissary dispute, and a witness reported that a gang was running the zone and controlling commissary. I'm going to skim through this section as well. Basically, the jail is woefully inadequately staffed. That's often one person for an entire zone. This is an example. Violence occurs as a direct result of the understaffing. In August of 23, a single detention officer was assigned to monitor a housing unit of nearly 100 incarcerated people overnight. So 1 to 100 staffing, over 100. He left to go get ice. Confusing, but okay. Upon returning at about 1 a.m., he saw 3 incarcerated people fighting in the day room. 2 were drenched in blood. One person involved in the fight told officers that he saw one of the other people trying to leave the cellar zone and took it upon himself to stop him. I would have done that. Similarly, the September 22 homicide occurred when the floor officer left his assigned unit of around 100 people to deliver paperwork and exchange his taser cartridge. While he was gone, incarcerated people alerted the tower officer that someone was laid out on the floor. The tower officer called the floor officer assigned to another unit to respond, presumably leaving that unit unattended. When that officer arrived, the victim was face down in a puddle of blood. Properly conducted well-being checks, referred to as security rounds, are critical to the safety and security of people incarcerated in the jail. During security rounds, officers verify that all people are alive and well, learn of any urgent needs, identify security concerns, like broken locks, and provide a presence in the housing units to deter misconduct. Security rounds should occur at irregular intervals with no more than 60 minutes between rounds. That seems pretty common sense. I know someone who's put in a dorm with a rival gang. When he first got to Rice Street, he was jumped and had to spend a few days at Grady. I'm sure. I'm not surprised with that at all. The reason they're accusing of running the jail was mentioned by Viverito in the YSL trial. Of course it was. No comment. For now. There aren't hourly rounds. Surveillance cameras, they help, but they're not substitutes for actual presence, of course, especially if you're not watching them. Staff are often unaware of extreme violence, leading to lengthy delays in response times and medical care. May of 24, despite an obvious assault where 2 incarcerated people fell down a staircase in a housing zone, over 2 hours passed before officers found the victim wrapped in a bloody towel. Over 2 hours. In January of 23, an incarcerated man reported that he was brutally assaulted over 4 days, but officers were unaware of the attacks until the man passed a note asking for help. In the November 22 killing occurred, the overnight floor officer on the mental health unit was actually working inside the tower. When the officer eventually conducted security rounds, he found the victim lying on a cell floor with his hands tied behind his back and his ankles bound. Medical determined that he was already dead and extremely cold. There's a budget crisis with respect to paying both jail employees and contractors. It's basically chasing bad money after good by hiring more and more expensive short-term solutions rather than fixing the underlying problem. Okay, this is one of the crazy sections. Poor maintenance and pervasive contraband contribute to the violence. The county and sheriff's office have not taken measures to maintain the jail facilities. Poor supervision, jail maintenance, and security practices contribute to a large amount of contraband, including weapons and drugs and unsafe facilities. The result is a highly dangerous jail. Jail leadership is aware of the danger these conditions pose to incarcerated people, but has failed to fix it. In the bushes, but wanted to say this is such an important topic. Thanks for never letting up on them. Yeah, I mean, it's not like I'm, staying on an old thing. They just continuously do it, so it's relatively easy to. Oh, sorry, I just got a client text. Give me 1 second. Sorry about this. It's actually about Fulton County and me getting on them, so this is kind of funny. This is hopefully something that I will be able to tell you about very soon. Okay. I think the big holes in the building on the 5th floor. We're getting there. Don't worry about that. Mary says, I have to go. The pain meds are doing what they're supposed to. Oh, that's good. Get some sleep. And anytime. Due to poor maintenance and inadequate supervision, the jail itself is a source of dangerous weapons and exposes people to violence. Many high-risk housing areas, almost none of the pipe chase doors close and lock because the locks have been vandalized and not repaired. At some point, you have to have locks to be a jail, I think. I'm not even sure it's like really a jail because it doesn't really lock. You need a different word for it. As a result, incarcerated people can access pipes, controls, and pipe fittings, which they easily make into weapons. In October of 23, a dozen people attacked another man, hitting him in the head with an 8-inch pipe. In August of 23, 4 men attacked another man with makeshift weapons described as knives and metal switch plates. During our visit in February 24, in one maximum security zone, is it really a maximum security zone? Almost every pipe chase door could not lock, and large pieces of metal, easily made into weapons, were lying on the floor. The officers escorting us during the site visit appeared unfazed by this situation. when one of our expert consultants identified a significant piece of metal found on a pipe chase, an officer said to drop it on the floor of the day room where incarcerated people could easily access it, and they'd just get it later. Maximum security. Just a month before that visit, an incarcerated person used a metal plate and a long sharpened nail, an attack in which 2 people received serious injuries. I'm not a plumber, but this looks bad. Let's see. Fulton County reported confiscating 2,100 shivs in 2023 and 1,300 in 22. Jail confiscated at least 139 man-made weapons in the first month of 2024. Oh, thanks, Kat. For example, in Miami-Dade, about 1.5 times the size, staff confiscated 346 in 23 and 519 in 22. So, 3-ish times the quantity. Condemned in every sense of the word, Lexi. Weapons recovered in the jail and shown to the DOJ team. This is just a door. I don't know about this one, but yeah. Fulton County blue. Looks like these are probably made from the uniforms. The inmate uniforms. Not that I'm advising anybody to do that. Light sources throughout the jail have also been tampered with, further increasing the danger inside the facility. Incarcerated people pull lighting fixtures out of the wall to access wiring, hide contraband, and obtain metal switch plates for weapons. This isn't the only type of electronic that the inmates have control over, but we'll get to that. September of 23, one housing zone had missing electrical switch plates in 5 cells and multiple broken day room light fixtures, all with wires exposed. In August of 23, the jail reported finding 543 broken electrical fixtures, with 292 still needing repair. That's more than half. A little math there for you. The poor lighting increases the risk of violence and means that some people in the jail live in darkness. Again, I can definitely verify that. On top of broken light fixtures, extended power outages have threatened the safety of the population. We identified 7 power outages since January of 22. July of 23, a power outage left the main jail pitch dark for several minutes with no emergency lighting in the corridor. Eventually, the lights were restored, but the electrical and HVAC system outage lasted 6 days. Also, I don't know I think it was after the YSL trial, but there was a day where the elevator for defense lawyers was broken. And so they were saying that defense lawyers couldn't access their clients in the jail. I assume there were other elevators or stairs because somehow they had to get in there. But that was a magical day. Jail leadership is aware of the dangers caused by the poor conditions. In March of 23, a search conducted by the sheriff's office identified over 200 man-made weapons. Sheriff Labatt acknowledged that inmates are literally crafting shanks from the crumbling walls of the dilapidated facility. I'm not a Labatt fan, by the way. It says they pull down the broken light fixtures to defend themselves, and then they get indicted for it and have to plead out just to get out despite being acquitted of what they were in there for. Yeah, totally. I mean, that's definitely kind of the theme. Well, one of the themes, I guess, is how the jail makes significantly more trouble than it saves. They're doing a repair blitz. They're trying to fix stuff, but they're, not doing great. Okay, this is one of the sections I really wanted to get to. Poor door security in the jail threatens the lives of incarcerated people. Door locks throughout the main jail do not work. That's a hell of a sentence. See, this is real. This could just be like a whole report right here. No, not you. This in and of itself should be enough to raise some red flags, because that's really like what a jail does. That's like, that's your only job. That's kind of what this is. It's one of those scenarios. Like the door is like you put, you detain people. So to detain people, you put them in the room, and then you lock the door. Like that's the whole thing. And I'm not even like saying I support that, but like that's the idea, is that the door locks. That's really the critical part of the jail, because you can just put somebody in a room, but if they can walk right out, they're not really detained, right? So the lock is really the part that you need to worry about. That's the whole thing. So door locks throughout the main jail do not work. In March of 23, a deputy reported to jail leadership that only 5 out of more than 100 doors on a unit were working. 5 out of more than 100. I'm kind of proud of him for like if I got to like if 1 out of the first 20 don't work, I'm not going to check all 105 because it's already a big enough problem. I don't need to know that it's 5 out of 100. It's like, hey boss, all the doors are broken. Oh, 5 do work? I'm sorry that, 5 work when I said all were broken. In August of 23, the sheriff's office reported that it had identified 732 broken door locks in the main jail and still needed to repair 653 of them. I'm not even going to get into that. The incidents we reviewed demonstrate that malfunctioning doors are a major security failure and a serious risk to the safety of incarcerated people. You don't even need to review incidents to know that. In August of 23, multiple incarcerated people left their housing zone armed with sharpened weapons. They opened the door of their zone by wedging a dustpan in the door and manipulating the lock to slide the door open. That doesn't sound like a lock. You need to call it something else. And also, where do they get a dustpan? Or the weapons? Okay, this is what I was talking about with electrics. On certain floors, incarcerated people have been able to trigger emergency release mechanisms and pop open all the doors on a tier at once. Not just their own door, they can open all of the doors. In March of 23, 2 separate stabbings occurred over the course of one night after incarcerated people manipulated the override mechanism to open doors and attack people. Well, I guess at least the door opening mechanisms work. So that's good. In July of 23, in another incident involving the door locks on that same zone, 3 assailants stabbed and beat someone. The sergeant who reviewed the assault wrote in his report, "This attack happened in a lockdown restrictive housing zone with sliding cell doors that the inmates can open and close at will by manipulating the manual override mechanism that controls the cell doors in the zone. This is a very well documented issue that has been going on for months yet never rectified. Due to the security breach, inmates are no longer protected from other inmates because the cell doors are so easily opened by the names." I imagine the sergeant is very frustrated. If you're good at your job and you want to do a good job, you can't. It's hopeless. Why bother? Yeah, I'm not surprised to hear that, Aaron. Aaron says, unfortunately I'm aware of a couple instances where the opening function does not work either. Yeah, I'm not surprised. 3 months later, in October of 23, the situation had gone from bad to worse, and the locks did not work. So they don't even need to open them. A deputy assigned to the zone reported all the doors in this zone are broken, with also inoperable manual release boxes. Okay, Aaron, you beat me to the punch there. No inmates should be housed in the zone due to the fact that no one can be secured behind a locked and operable door. The jail continued to house people on this unit for another month before shutting it down. The jail could provide secure cell doors and keep door locks in good repair. The failure to do so is the product of inattention. The jail's contracted maintenance worker reported that the locks work if not vandalized. Again, that's not really great. Like, you need it to be not to work if it is vandalized, because like people want to get out or in. So again, that's really the whole thing. If you can open it by vandalizing it, it's not great. He described locks being jammed, torn up, broken, and unable to be opened or closed because materials were stuffed in mechanisms. Again, repair blitz. Okay. This is one of the people move through the walls of the jail to attack others. They probably should have phrased that differently. They're not ghosts. They're not, ephemeral beings that, transcend physical matter. They move through holes in the walls. Inadequate supervision and the poor conditions of the jail have allowed incarcerated people to create large holes in the walls through which they can travel and cause harm. The sheriff's office has publicly acknowledged this issue. What did that press conference sound like? Look, we're aware of the holes in the walls of our jail, so people can just kind of move around whenever they want. Yep, that's fucked up. Anyway, in January of 24, officers reported a hole in the shower of 6 South, Zone 600, leading into the pipe chase of Zone 500. You know what's interesting is Zone 500. That's where the Mender and Nichols, Aaron was asking, or Aaron, somebody was asking about that earlier. Zone 500 was one of the zones where there was a riot in May of 23. Days later, a floor officer in Zone 500 noticed 2 people inside the pipe chase and reported a big hole in the wall leading to the Zone 600 shower. Yeah, that's worthy of report. It is concerning that this hole had not been repaired and that the floor officer was unaware of the hole's existence even though the staff had already discovered it. That's something that you should tell your employees so they know about it. September of 23, one zone was found to be severely compromised when officers found that multiple cells had holes leading to a pipe chase door that had been forced open and did not lock, allowing people to exit their cells at will. Officers determined that incarcerated people were chiseling through the concrete to make these holes. What do you mean you determined they were chiseling through the walls? Like there's a fucking hole in the wall and the concrete's gone. Did you like dust for fingerprints or something? In May of 23, an assailant dug a hole through a shower wall to enter an incarcerated person's housing zone and stab him. Later that month, a fight broke out between people on 2 different zones. This is probably the Mender incident. And an incarcerated person told officers that he was lying on his bed when an assailant came through a hole near the toilet via a pipe chase and stabbed him. That's horrifying. In March of 23, an officer observed that an incarcerated person had made a massive hole in the wall of his cell leading into the pipe chase and a neighboring cell. Later, the same person was on another zone when he climbed from a hole in his cell, through a pipe chase, and into the day room where he chased another person about the zone. These aren't really cells anymore. They're just like rooms. Like a cell kind of implies like, a single discrete housing unit. But if you build yourself an addition by digging a hole in the wall, it's not really a cell anymore. It's like it's just a room with a small door. The widespread availability of metal pieces may be contributing to the number of holes, as is overall poor maintenance and inadequate supervision. With regular and thorough inspections of housing units, incarcerated people likely would be unable to create large holes in living areas. Yes. How do you see the holes? How can you know the holes? In the words of Cardi B, you just look. Drug use is common and leads to violence. That's kind of, speaks for itself. Drug use plays a clear role in violence. March of 23, an officer observed a fight between 2 incarcerated people. One was incoherent and unable to be interviewed after the fight due to his high level of drug usage. High level, that's funny. The other person involved said he had been defending himself from attack. Another incident the same month, multiple people assaulted and stabbed a person who was so high that he could not stand up or walk straight. People may incur debt, which leads to violence when money doesn't get repaid. Jail does not take appropriate measures to prevent the movement of contraband. Again, a lot of this is repeated, but there's one part. This is what I want to read. One officer reported that to reduce the number of weapons in his zone, he would announce to the incarcerated people housed there that he needed to find 10 weapons on the table when he returned to the zone. He would leave the zone, and when he returned, there would always be the right number of weapons on the table, which incarcerated people presumably placed there to prevent a search. This approach to contraband control is concerning for several reasons. First, it suggests that additional weapons remain in the zone. Second, incarcerated people likely pressure the most vulnerable people on the unit to surrender their weapons. Incarcerated people have burned holes into windows with the apparent purpose of receiving contraband from drones. In May of 24, officers found various contraband inside a cell that had a hole in the window. To be fair, it could just be that they have a hole in the window in contraband. Like, oh my god, there's a drone is kind of a leap. Because like all the other rooms have contraband too. It's really just the hole in the window. More than 2 weeks before this incident, officers had identified that a burned out window in the cell left a huge opening for contraband. You know what it also is a huge one for? Air. Fresh air. Sunlight or light in general. Like jumping straight to drone, that sounds like you just want to have a drone of your own. And so you need to, like invent drone attacks on the jail. Like the fucking doors don't open. Why do you need a drone? They can just hit Arby's on their way back to the cell if they need to. What are they going to use drones for? They can just dig a hole to fucking Raising Cane's and then ask for funding. Exactly. There's one of the inmates that I'm working with is at a jail. Not a jail, in a prison. This is unrelated. And I don't know if you guys know, but like 2 or 3 months ago, there was a massive gang war inside of Georgia prisons. It was between, I think it was Bloods. It was one blood set. I don't think it was all Bloods. And the Nation of Islam. So the Muslims and the Bloods had beef. And a bunch of people were, a couple of people were killed. There was statewide lockdown, 23-hour lockdown, if not more. And this was one of the few prisons where the inmate I'm working with, he was at one of the few prisons where there was no, the war didn't spread there. There was no violence. And their reward was Raising Cane's. Their reward for like not engaging in open gang warfare was like mediocre fast food chicken. I would stab somebody just on principle at that point. Like that's what I get for not engaging, for not murdering somebody is Raising Cane's. No disrespect to Raising Cane's. Actually, no, disrespect to Raising Cane's is intended. Insane. I don't know how I got onto that tangent, but I did. Window holes were visible from the parking lot. Security staff seemed to be aware of this issue, but still housed people in the cells with holes in the windows. There are holes in the fucking cell. You don't need to worry about the holes in the windows. That's the least of your concerns. The hole in the window is secondary. The hole in the cell wall. I like their toes. I haven't had that. Okay, these are apparently holes in windows. I'm glad they gave us a picture to see what a hole in a window looks like. Corrupt staff are also a significant source of contraband. 4 private security officers were arrested for trafficking. People weren't screened. Completely unsurprising. The jail has inadequate systems for identifying, investigating, and one second, another text from a client. That inappropriate relation. It could be. It probably is. Does not meaningfully respond to grievances and complaints from incarcerated people. Okay, getting to the end of this, of what I'm going to read. I'm definitely going to read this section because it's really important. Grievances are an important part of a jail system. They provide incarcerated people with an avenue to have problems corrected and jail administrators with a source of information. Jail, however, fails to adequately investigate and respond to grievances filed by incarcerated people, including those submitted for personal safety. Incarcerated people are supposed to submit grievances through kiosk in the housing zones, yet we observed inoperable or missing kiosk. How is the kiosk like inoperable? Okay, fine, like it happens, but how does the whole thing just dead ass just go missing? Like, did somebody steal the kiosk? Did somebody like build a shank out of a kiosk? Okay. There are paper grievance forms, but they are not readily available. The grievance coordinator admitted that most grievances raise security concern or safety concerns. Hold on 1 second. Oh, that's concerning. Yeah, well, that's on brand with what we're talking about right now. Oh my goodness. Sorry, I need to be mad about something else for a second. Okay. Oh, I'm so bad. Okay. All right. I can get through this. Okay. One homicide victim submitted 13 grievances in August of 2023, the month he died. In 5 of these grievances, he reported experiencing violence from other people at the jail. In a grievance submitted shortly before he was moved to 7 South, he reported that officers were trying to move him to a more dangerous location because he had reported them for misconduct. He explained that moving him was dangerous because he had issues with people on multiple floors. The grievance officer did not respond until a month later, at which point the officer wrote, "This grievance is over 30 days old. If your issue is still unresolved, please resubmit your complaint. This office apologizes for the delay." By the time of this response, the person had already been moved to 7 South and killed. Butt Nugget's mom asked, "Can we not join Jim's channel yet?" No, not yet. I haven't been monetized yet. I probably will after this stream, though. I think I'll hit 3,000 hours after this. No, I don't have the hours yet. In August of 23, an incarcerated person submitted an emergency grievance alleging that he was assaulted that day by another person in his zone. He further alleged that his assailant had assaulted someone else 2 days before the attack, that officers had failed to remove the assailant from the zone. The grievance officer decided the grievance was improperly filed as an emergency, told the person to refile on a general grievance form, and closed it. You need 3,000 hours in a year. I'm pretty close to it. 3,000 hours of viewer time. Just, I should do that, Kat. Again, I don't want to get into sexual violence just because it's, a sensitive subject, but the reports to that are also ignored. Jail does not use quality investigations. Well, that's just, that's kind of the specialty. I want to skip through this. Excessive force. I'll read a little bit of this. Fulton County jail officers have a pattern or practice of using excessive force. Staff frequently resort to unnecessary force, especially the taser, when people are not actively resisting or posing a danger to themselves or others. When force is justified, staff use a greater degree than necessary based on the circumstances. The jail lacks adequate policy or training. You could really just stop right here. Got to do it for Boo. That's really the whole thing. Force technique sounds like we're talking about like Jedi. Anyway, the jail fails to adequately investigate uses of force or take sufficient steps to prevent excessive force. Talking about this legal standard for use of force. County produced use of force reports from January to 23. A lot of it stems from inadequate staffing When a single officer is alone in a housing unit with multiple incarcerated people, it is more likely that they will resort to using OC spray, like pepper spray, or a taser to assert control instead of first attempting to de-escalate or less dangerous force techniques. That makes sense. I mean, I can't even blame an individual officer for that. If you're outnumbered 100 to 1 and you're getting involved in an altercation, you kind of have to use more force just to make sure things don't get further out of hand. Not, excusing it, but I can understand it. Officers regularly use force when no force is necessary and routinely use force that is disproportionate. Fulton County officers routinely use unreasonable force, often without first attempting to resolve the situation. In some cases, officers do not even give commands or verbal warnings before resorting to force. Describing what a taser is. We found that officers at the jail respond to minor transgressions with force. For example, in August of 2023, an officer told a man to retrieve a basketball and give it to the officer. According to the officer's report, the man did not comply, so the officer fired his taser for not getting the basketball. Officers also use force in the absence of a threat and when faced only with passive resistance or no resistance at all. Among the use of force incidents we reviewed, the overwhelming majority involved passive resistance, not, fighting back. In those situations, officers often do not attempt to de-escalate, but default to using force. In August of 23, an officer sprayed a man with OC spray without warning for failing to pack up items after an officer ordered him to do so. In June of 23, an officer twice used a taser on a man who was yelling and swearing in protest of a television removal. The officer did not give any commands or use any de-escalation techniques. In July of 23, officers fired a taser at a man who argued and refused to hang up a phone. The man eventually hung up, but one of the officers fired a taser at him anyway. Excessive force is so commonplace in a jail that officers have a cavalier attitude when it occurs. In July of 23, a sergeant sprayed OC spray, at 2 incarcerated people in 2 different contexts within 10 minutes. Body-worn camera footage shows that neither person physically or verbally threatened staff or others. The sergeant called both people idiots after using OC spray, and another officer told the sergeant, "Man, Sarge, you're on fire today." Cool. September 23, an officer punched and OC sprayed a 17-year-old boy during a struggle that followed the officer's removal of a zipper from the boy's uniform. The boy had a recent history of using zippers to cut himself, but the incident reports no attempt to summon mental health staff or otherwise de-escalate before the officer ripped the zipper off by force. In March of 23, officers tased an incarcerated man who said he felt like hurting himself and he needed to see mental health. Rather than taking the man to mental health, the officers tried to make him return to his housing zone. A sergeant tased the man when he held onto a bench to avoid being forced back into the housing zone. What I find particularly disturbing about that is that in the earlier section of the report, they were saying that people with mental illness were being targeted in their housing zones for violence. So it's perfectly rational. Like a rational person would behave like this, to refuse to go back into the housing zone, and that they were OC sprayed. I wish I could send my neighbor upstairs to my street. Fair enough. I mean, there are some people I'm fine giving life sentences to. Innocent or not, I don't care. Sometimes officers are criminally charged for their force. A woman was swearing and resisting the booking process, but did not pose a serious threat. The officer told the woman, "I choke, folks, and hold your face before you lose your breath," as he held the woman's neck and she lost consciousness. Officers from a local police department reported the incident. The Fulton County officer pleaded guilty to federal civil rights violations in August of 24, was sentenced to 4 years in prison. Fulton County officer's supervisor was present during the incident and failed to intervene, instead commenting, "Oh, now she is trying to pass out." Really? The supervisor received a 1-day suspension for her conduct. 1 day. So you have even less people working than you did before. In July of 22, 2 officers fired taser at a man who had just had a seizure. They reportedly tased the man because he reached his hands towards a lieutenant's belt while they were putting him on a stretcher. The man fell or jumped from the stretcher and screamed and writhed on the floor. When he tried to sit up, the officers tased him again. They used several additional taser cycles on the man while he thrashed on the floor and continued screaming. After the last cycle, the man said, "I can't breathe." Medical staff approached and told the officers to stop because the man has had or was having a seizure. So I think you get the point. This is just saying that the guards aren't given guidance on when to use and not use force. They don't review use of force. Go over with the officer. I mean, sometimes force needs to be used, but you can review it after the fact. No discipline for use of excessive force. So it's basically carte blanche. I'm not going to read this in too much depth, but the 8th and 14th Amendments require jail officials to maintain facility conditions in a manner that promotes the safety and health of incarcerated people and prohibit housing people in unsanitary conditions. I didn't read the header. The jail is hazardous and unsanitary. Housing units are full of flooded water from broken toilets and sinks. Cockroaches, rodents, and other pests abound, and the jail takes insufficient steps to control infestations. Cells and common areas are filthy and unhygienic, with dangerous exposed wires. The jail does not provide enough food, and food preparation and distribution services are not sanitary. These conditions make the jail unsafe. People incarcerated in the jail have suffered from pest infestations, malnourishment, and other harms. Let me see. There's broken sinks and toilets, so everything floods. Leaks in jail pipe chases are a systemic problem. There's water everywhere, probably mold. The drains in some of the padded cells, which function as toilets, had trash and apparent human waste in them. And several padded cells smelled strongly of feces. One padded cell also appeared to have fecal matter on the ceilings and walls. And Lil Woody testified to that during the YSL trial. Toilets are filthy, and we observed clothing items in them, indicating self-laundering practices, as discussed below. People are doing their laundry in the toilet. Toilet and sink unit. Air quality and ventilation in housing units is poor. Air vents are dirty and blow dust and debris onto ceiling tiles in the housing areas. Exposed wires are a hazard. A medical provider noted that a person with serious mental illness had pulled wires out of a wall and talked about electrocuting himself. In December of 23, an incarcerated person set a blazing fire inside a restrictive housing area, resulting in evacuation of 15 incarcerated people and closure of an entire housing zone. Despite smoke from the fire filling the zone and becoming so dense as to obscure the view of cameras, officers only realized there was a fire when they heard loud banging from the housing area. The one incarcerated person reported that the residents locked inside their cells felt they were suffocating and attempted to get air from under their cell doors. Timestamps on security footage indicate that residents were evacuated 21 minutes after the fire was first seen on video. Not when the fire started, but when it was seen on video. It's unclear how the person started the fire, but the extent of the damage and slow response shows the risk, systemic risk. The lack of laundry services increases the risk of infections, fungus disease, and disease-causing microorganisms. There's inadequate pest control that includes like lice and things that physically affect humans, bed bugs. That's how Sean Thompson died, which is one of the things that triggered this report. The jail lacks adequate chemical control. There are instances of people using bleach as a weapon because they could just go and grab it. Food is insufficient and nutritionally inadequate. In September of 22, medical staff determined that 90% of the people living in the mental health housing unit where Mr. Thompson resided were significantly malnourished with obvious muscle wasting. Medical records show that other people in the jail have suffered from malnutrition and hunger. Incarcerated people we spoke with described experiencing hunger. They explained that extortion for food is common because of the limited food supply. In one case, an incarcerated person who was tased after he took an extra lunch sack explained that he did so because he has diabetes and was hungry. The food is garbage, nutritionally inadequate, which doesn't meet basic needs, either in terms of caloric count or, vitamins, not hitting their macros. The food is itself unsanitary. There are cockroaches everywhere, bug droppings. The food isn't hot. It's dangerously lukewarm, really. There is no health care. The reason I'm skipping over healthcare is because we're going to be looking at the still ongoing case of Shane Kendall, and that involves a lot of the healthcare stuff. So I'm going to be addressing the healthcare part and probably the next stream I do on this topic, or maybe 2 more from now. That's why I'm not going to go too much into the health stuff. Okay. NAFCare specifically is a defendant in that case. NAFCare was the contracted health provider. Yeah, I don't want to cover this yet. I think this is most of what I wanted to get into. Let me see. Yeah, screening, drug withdrawal. I think this is everything. So we're going to have to switch gears in a second. Healthcare, experience, door conditions. This is also something I'm going to explore in a different video. People are put into, this is true in the prison system as well, people are put into solitary confinement for just amounts of times. That would be a war crime if they were done in a war, via the Geneva Convention. Okay, yeah, that was everything. Okay, so again, the point is that the jail is terrible, and it's a terrible place to be for many reasons. It's gross, it's dangerous. If you're in a gang, it's dangerous. If you're not in a gang, it's dangerous. There's a lot of pressure to get out of there. And that is a feature, not a bug. Can you guys see this? Let me see. There we go. I think Aaron mentioned this. This is one report. We're going to do more reports in the next one, I think. But this is just a random affidavit for arrest based on a riot. Detention officer Sweeney was assigned to 5 South as a floor officer. After responding to an emergency incident on 4 North, Zone 500, Officer Sweeney headed back to her floor. Upon entering the 903 door, she overheard loud commotions coming from a zone. As she entered the floor, she noticed the zone doors to zones 400 and 500 open and inmates were fighting. So again, the dividing door between these 2 different zones was open. Sweeney radioed for additional officers. She next witnessed inmate Joel Garland with what appeared to be a metal pipe, which could be used as a weapon. Sweeney upholstered her Fulton County issued taser and deployed 1 cycle into inmate Garland's upper chest. Sweeney then radioed again for additional officers. While waiting for assistance, she continued to give loud verbal commands to both zones to drop their weapons. Once additional officers showed up, they regained control. Both cell searches and individual inmate searches were conducted for both zones. Inmates appear to have been assaulted, include these people. I'm not going to read their names. After further investigation, Sergeant Battle reviewed the security footage, and it showed that at approximately 11 a.m., inmate worker Madre Lee is seen talking to inmates at Zone 400. Lee checked Zone 500's door to ensure it was not locked. That's funny. It's not like he unlocked it. He's just making sure that it wasn't locked. He didn't want to be surprised and have the lock actually work. An inmate, later identified as Inquirus Mender, slides open the zone door to Zone 400. 3 inmates join him in attempting to open Zone 500 door. Once 500 is opened, inmates from 400, with inmate Mender, Inquirus Mender leading them, they block the door to the now open Zone 500 door, I guess. From the video, you can see inmates with padded clothing, as well as having their necks wrapped in torn sheets. Sounds like they're prepared for battle. Antonio Waller, standing in the doorway with clearly identifiable weapon in hand. Inmate Mender is seen talking with inmates in Zone 500 while standing in front of the other inmates from 400. So he has his guys behind him and he's shouting into the other zone. Other inmates from Zone 400, one with a door hinge wrapped in a socket, Antonio Johnson, tried to enter the zone and was told to stand down by Mender. From the video, Mender is the one controlling the situation. Well, it's certainly not the jail staff. At approximately 11 a.m., Mender makes entry into Zone 500. At a minute later, all the inmates begin to push their way into the zone. Marvius Nichols throws a cooler of a liquid substance into the zone. At approximately 11:02, inmates in Zone 500 begin coming out of their cells with weapons. So this is now an armed battle. Inmates from both zones are now seen assaulting one another inside of Zone 500 with various weapons. At 11:04, 3 unidentified inmates go up the stairs in Zone 500 and begin chasing an inmate on the top tier. They chase him into 518, where they stay for a while, and then the inmate is seen running out of cell 518 and back towards the other end of the top tier, where there is minimal lighting and visibility. At 11:05, Sweeney returns to the floor, and inmates begin to disperse. Sweeney is seen giving verbal commands and utilizing her taser to taser inmate with a weapon. At 11:06, additional officers arrive on the floor and assist in regaining control. Searches were conducted. Inmates who were assaulted were identified and escorted to medical. So, pure chaos. Actually, I should say this crime, it sounds like there actually was a riot in this case. Riot in a penal institution extends to like any kind of disturbance. You'll see people charged with a riot in a penal institution for like getting into a verbal argument with somebody. Okay, now I need to take like a 2-minute break. When I come back, ooh, do I not have it open? But it's my favorite one. Yeah, here we go. We're gonna visit with Raven Liberty because she did some funny stuff that I want to talk about. She did some stuff again. She did Raven Liberty stuff, and I just want to update on that. And I have some judicial misconduct that's kind of funny. I shared it with Kat. Hey, good to see you. I do need to take one break. I'll be like 2 minutes. I'm gonna turn my camera off, but I will be right back. And yeah, then we'll get started on that stuff. So, see ya in a second. Okay, Matthew, look away for a second. Show my puppy. Okay, let me make sure you can still hear me and everything. Looks good. Just to lighten the mood, I think I'm going to read this first. Sweet lady, after watching all of the live stream cases and directing attorneys, I feel motivated to pursue the legal path. You should. I'm going to start with this disciplinary hearing, but we'll get to Raven Liberty soon. I just need to lighten the mood after all that because going straight into roasting a defense attorney after all that doesn't seem very I don't know, very suitable. Sorry, one last client thing. Okay, hey Weppy. Okay, so this is I found this randomly. I was looking for a disciplinary report for another judge, Amanda Williams, which I found after this. And this one is I don't even know how to describe this. It's special. Let me make sure. Oh, you can't really see that. Here we go. What do you make of Munktunk's appeal? I think that whoever wrote it is super talented. Probably really good looking. Funny. Personable. Yeah, I think it's I wrote a lot of it. Yeah, I think it's very strong. Obviously I believe in it because, it's mine. But I think some of it's just objectively true. Like the lack of a sentencing hearing. And we could have done more on that. But it's just that's just it's an objective error. Thanks. Yeah, a lot of the appeal was taken from our second motion. That basically we had to do the appeal before we could do the second motion, so we took some stuff from that and put it into the appeal. So a lot of that stuff was written quite a while ago. But okay, wait, is this the right one? This is the right one. So this is in Georgia and in most states, the Supreme Court can fire judges for misconduct. I can't believe Kat read that whole thing. I got to listen to that. So this is a judge who got in trouble, and we're going to listen to what he did to get in trouble. After receiving complaints, the chief magistrate judge initiated an investigation. Following the investigation, the Judicial Council filed charges to have him removed from his position as judge and barred from ever holding or seeking elected or appointed judicial office in the state of Florida. Okay, once in a while, somebody will like comment on my posts. They're like new to the situation, or they don't know who I am, which they have no reason to, but they'll be like, you should look into Mooktook's case. That always makes me smile. I think Whitaker purposely forgot to acknowledge part. No, I don't think so. I think she just missed it. We can actually get to more stuff, more issues now than we could have if she'd granted the motion, so that part's a positive. The weight's obviously bad, though. Having reviewed the record and for the reasons that follow, we agree with the recommendation and order that Judge Peters be immediately and permanently removed from the bench and be barred from ever holding or seeking elected or appointed judicial office in Georgia. The record reveals that a hearing was held 15 years ago, and the Judicial Council found that Judge Peters had violated Canon 2 by obtaining and consuming marijuana at least once a week from March to May of 2010, whatever. Inappropriately used his judicial office to advance the personal interests of a family member by showing up at the house of his sister-in-law's estranged husband, identifying himself as a magistrate judge, and then kicking in 2 interior doors at the man's home to gain access to 2 bedrooms. 3. Violated Canon 2 when in the spring of 2009 in Catoosa County Courthouse, he pointed a firearm at himself and indicated to another magistrate judge that he was not afraid to die by saying, "I am not scared. Are you all scared?" Violated Canon 2 of the Code of Judicial Conduct by appearing on a local cable television show called Night Talk on June 21st, 2010, and A, making derogatory remarks about the chief magistrate judge and calling him spineless, B, publicly disclosing that he had filed a complaint with the Judicial Council against the chief magistrate judge, and C, displaying a photograph of an individual and identifying that individual by name as a confidential informant of the Catoosa County Sheriff's Office, which just is incredible work. Just exposing essentially an undercover informant on television, not just like to a person, which would be bad enough, but who is the chief judge? Let me see. But on TV, the chief judge was Sonny Caldwell. Where were we? Okay, next. 5. Violated Canon 2 by making a phone call to a local cable television talk show, and after initially trying to disguise his voice with multiple foreign accents while speaking with the Catoosa County Sheriff, who was being interviewed on. So the sheriff's there, he's on the show, told the sheriff that he had crapped himself and that the sheriff was a spineless jelly spine. I would give so much to be able to hear or see this show. Violated Canon 3B by refusing to work certain hours that had been specifically assigned to him by the chief magistrate. They actually showed the episode at his hearing, which is kind of funny. Based on all of the proven allegations, Judge Peters' conduct violates Canon 1, which requires judges to establish, maintain, and enforce high standards of conduct, so the integrity and independence of the judiciary may be preserved. About that. This is another roast here. The evidence of record here clearly establishes the violations of Canon 1, 2, and 3. Judge Peters readily admitted to much of the misconduct at the hearing, but simply believed that he had been disciplined enough by having been placed on paid leave since June 16, 2010. Notwithstanding Judge Peters' personal belief that he's already received appropriate discipline, The record reveals that Judge Peters has not sought treatment for his admitted drug problems. I don't know about that. And has done nothing to show that he has any ability to live up to the high standard of conduct expected of members of the Georgia judiciary. Indeed, after using illegal drugs, forcibly kicking in doors at a man's home at the request of a relative, pulling out a gun in front of at least one of his colleagues, and being suspended from his job for refusing to work hours assigned to him, Judge Peters consistently refused to take responsibility. Instead, he spent his time, while on administrative leave, publicly disparaging the chief magistrate judge and the sheriff of Catoosa County, and endangering the life of a confidential informant by exposing his identity. Trikisha says paid leave is punishment. Yeah, that's what they're getting at. But 12, Judge Peters has failed to explain exactly how being paid his full salary while staying at home somehow constitutes appropriate discipline, as again, he has made no filings in this court. The public deserves much more from its judicial officers, and those officers who cannot give the public what it deserves do not deserve to hold office. Accordingly, it's hereby ordered that Judge Peters be permanently removed from office immediately and be barred from ever holding or seeking elected or appointed judicial office in the state of Georgia. So no, the unpaid leave was not punishment in the eyes of the Georgia Supreme Court. And, just common sense. Jack Lew. He's retired, right? Jack Lew. I always go back and forth between whether he's, like senile or, I don't know, mimicking senile. Like sometimes he looks physically unwell. I mean, I haven't watched him in a while, but sometimes he looks physically unwell when he's talking. Anyway, I wanted to lighten the mood a little bit before I get into Roasting Raven. That's what I should call. I should have a segment called Roasting Raven. Let's see. This one is funny. Okay, I just want to show you one thing from this filing. Let's see, can you see? Yeah, you can see everything. So this is a motion filed by Raven Liberty. For those of you who don't know, Raven Liberty was formerly YNW Melly's attorney in whatever county that was. I can just see what it was. It was Florida, Melly, Broward County, Florida. That's been pending for years now. She was fired. She fired, in the words of a celebrity. And she has been, I looked at her past work and it was actually pretty good. So something in her life seems to have, I mean, I shouldn't say that. Like, I don't know what the cause is, but the quality of her work has been extremely poor lately. And she works on like very high stakes cases. YNW Melly's case was a death penalty case. It still is a death penalty case. And the case that we're going to look at is it's a double homicide. And her work is not of a quality. It's not of an acceptable quality. And it's usually in a funny way. So I'm going to show you this. This was filed about 10 days ago. Defendant Demetrius O'Neill. That is the defendant. Glad you guys got the reference there. So first of all, this is not the detective's name. This is also not that detective's name. It's the second one's like this, and Wolfgang Daniels is lead detective. It's just Wolfgang Daniel. So both of the names are wrong in the title. And let me see. Expect the move to exclude certain testimony. It's actually, the substance of the motion is fine. It's just, well, there is substance, just not well presented. Demetrius O'Neill. So here it just switches to doublespace, just inexplicably. Dates formatted all weird. But anyway, that's not what we're here for. Or the fact that the name's spelled differently here. Whatever. Explaining why his cell phone reports are useless. Okay, here we go. So first of all, this is supposed to be like a section heading, like a title. Like in bold or something. It shouldn't be a number. The FMPD's methodology is not scientifically valid and therefore not reliable. This is supposed to be a section heading, not like a paragraph. But anyway. You know, on Friday, I was drinking and I came home and I made like a 3-hour video just breaking down these things, and I can never let those become public. Oh God. Okay, here we go. So number 17, we're looking at the numbers here. So we're 1 through 16. This is paragraph 17, right? Now we're on 18. Okay, so far so good. We're looking good here. We're gonna do a happy hour thing soon. Members only is not a bad idea. Okay, look, I got off track there. Okay, so 16, 17, 18. Then we go back to 16. Then we have another 16. Then we go to 19. Okay. I have 20, good, 21, 22, 23. We have 24. Then we have another 24. 25, 26, 31. I thought that was funny. There's actually a lot in here to discuss. But that's what we're looking at for this one. Now, this is my favorite. Actually, that's probably not true. It's up there, though. Okay, motion to suppress all pretrial identification, confrontation. I don't know why we want to suppress confrontation, but whatever. Demetrius O'Neill respectfully moves the court to suppress out-of-court identifications of Demetrius O'Neill. In support of this motion, Mr. O'Neill submits the following. Defendant Demetrius O'Neill, that's not his name. You see? That's right, puppy. He's very upset right now. He doesn't like it when names are messed up. See, they spelled the name right here, and they spelled it right here, but then they just didn't quite get there. And then it says Club Blue. That's also spelled wrong. There's no E. It's spelled like that because clubs have to be cool. And apparently clubs don't have E, which is counterintuitive. Okay. Oh, this is Matt. Just wait. Okay. Demetrius O'Neill. On August 3rd, 2016, witness Geraldo Belval gave a sworn statement to then, did I make a note there? Then lead detective Mike Walsh and Walt Mickey of the FBI. Geraldo Belval was present inside Club Blue. See, they got it here. They got it right here. The night of the shooting. Mr. Belval stated that the only problem he saw in the club was with one dude who kept flexing his money and that he was shooting. That is a problem. Mr. Belval states in sworn statement that the individual who he saw inside the club throwing money, and again outside of the club, hanging outside a red vehicle, shooting a long gun at the crowd, and ultimately killing Sean Achilles. That's not his name. You generally want to get the victims' names right because you look like a giant asshole if you don't. His name is Sean Achilles. He was 14 years old. As having big dreads, skinny, older than everyone else, and being in the 6 feet range. When asked to describe height, he further stated he did not recall the shooter having gold teeth, period, night of January 17th, 2016. Now we have we have Gerard Belval. So it's Geraldo. Now we have Gerard. It's not even close. Belval was standing outside Club Blue with the decedent when he witnessed a four-door red vehicle pass by. It's right there. Like, this is what... Belval was 100% positive that the shooter he saw in the, quote, small red car was the same individual inside the club and described above. On December 11th, 2019, while incarcerated in Glades County, Mr. Belval was subjected to a lineup, that's a weird way to say that, by the new detective, Wolfgang Daniel, which consisted of 6 pictures, 2 that were already known by Mr. Belval. After reviewing the 6 pictures, Mr. Belval exclaimed, "They got Linus in here." Nah, he didn't do that. He selected picture 2, which was Demetrius O'Neill as the shooter. Despite the identification made by Gerardo, wait, is that right? No, it's Geraldo. Yeah. So, damn it. We're now on to the 3rd iteration of this name. We have Geraldo, we have Gerard, and we have Gerardo. So we're up to 3. Despite the identification, Demetrius O'Neill doesn't match the description given in his initial interview. That's actually true. Demetrius O'Neill, as shown in the mugshot, does not have big dreads that are twisted. The funny thing is that if you look at the quote, it says, where are you? Big dreads that are locked. And I know, like, the wording isn't the same. They're both in quotes. Demetrius O'Neill stands at an approximate height of 5'6". He's actually, I noticed this the first time I read because, actually, it doesn't matter. I don't know why this is capitalized, but whatever. Then it goes, Demetrius period O'Neill had gold teeth the night of the incident. Demetrius O'Neill would have still been in his teens at the time of the incident. Gerard selected O'Neill, not knowing he did not meet any of the characteristics he previously described in his sworn statement. So this is going to be, that's very useful for cross-examination as opposed to exclusion. So having looked at the evidence, I think there's a good chance that this guy was not involved in this crime, which makes it even more egregious. The state should be prohibited from the introduction of any identification made by Gerardo Belval without him being present in the courtroom. I guess if he's just sitting there in the audience, it's fine. Nonetheless, this motion to exclude by Gerardo is filed in an abundance of caution. Okay, now this is the part that I tweeted about. The state must be precluded from introducing evidence that Mr. Eyewitness and Ms. Witness positively identified Mr. Client because the identification procedures violated due process. So, you might be asking yourself, who are Mr. Eyewitness and Ms. Witness, and who is Mr. Client? That's because she cut and pasted this from she cut and pasted everything. Well, she cut and pasted this from somewhere and forgot to change the names, the placeholder names. So, that's kind of embarrassing. Aaron, yes, Aaron. Then this is just randomly capitalized. I think this is supposed to be like a section heading. And then like this is a paragraph. I don't know. The out-of-court identification made by Gerard is unreliable. Should be excluded. She says that the lineup was unnecessarily suggestive. Doesn't say how, but she says it is. I don't know why this is italicized and this isn't. That's weird. Second prong. There's no way this is funny. That's, again, this isn't italicized. The out-of-court identification by Mr. Belval is unreliable and should be excluded. Said it was marked by suggestiveness and unreliability. Let me see. Matt says the lineup's admissible. I don't think it is. Like, it's self-admissible. It's more like maybe they could refer to it or something. I don't know. Mr. Belval should be precluded from making in-court identifications of Mr. O'Neill. Nothing about Mr. Witness or Ms. Eyewitness. No, it was Mr. Eyewitness and Ms. Witness. This should be italicized. This is wrong. This is wrong. This is wrong. So basically, this is just all about the identification. Okay. So that is the first one. Next, this is the state. They file a motion to strike. Comes now the state of Florida and moves this court to strike what we just read. The defense's motion is vague, broad, and unclear. It's vague and unclear. Wow. In the motion, the defense claims the state must be precluded from introducing evidence that Mr. Eyewitness and Ms. Eyewitness positively identified Mr. Client because the identification procedures violated due process. And I checked. The original was correct because it was cut and pasted, so of course it was. So the state, they made their own mistake. So they're not getting off scot-free here. I want to be clear about that. And also, this is not like, it was just a heading. It wasn't a substantive part. But they're just putting this in here to embarrass the defense, which, fair enough. Express an ID. The defense must, at the very least, indicate the names of the eyewitnesses. They did. It was Belval. Mr. Eyewitness and Ms. Eyewitness are not proper names. This was just all pettiness. Regard to the suppression of the ID of Belval. Nowhere in defense's motion does defense indicate what was impermissibly or unnecessarily suggestive. While defense may not like the fact that our client was placed into a six-pack that was identified by the witness, very debatable, there are no facts or details that support the lineup was improper. Check the time that this was filed. See right here. It was at 1:24 p.m. on August 28th. I think they were heard on the 29th. So, also on the 28th. So this is that evening, the same day, they have to fire an amended motion. And you'll see that they changed it to fix it. Although that's not his name, so I guess they broke it in a different way. I'm pretty sure it's Harrell, though. They didn't fix the name. But they did eventually. Have to shamefully fix it. Victim's name's wrong again. There is some more information in here. Well, to before. Oh, the numbers are right. Oh, wait, no, they're not. I was so ready to give credit because it. Also, why I don't know why there's space here. I was so ready to give her credit for fixing the numbering, and as soon as I do, it goes from 20 to 18. The second I give credit. There's no period here. Why? And now it's back to 20. Now we're at 22 because we skipped 21. I'm so mad. Yeah, Karen, you set me up. I think I want to read this one just because we're going to go through this one in detail because somebody has to. Okay. Defendant Demetrius O'Neill's urgent motion to compel exculpatory evidence. The defendant, Demetrius O'Neill, by and through the undersigned counsel, new sentence, inexplicably, files this, his urgent motion to compel exculpatory evidence, and as ground of support of thereof, I think? This is what thereof states as follows. The state of Florida has provided various 911 calls and transcribed 911 calls and dispatch notes. Okay, and keep in mind, this underlying all of this nonsense is actually like a fair request again, that's kind of what makes this troubling to me, among other things, is that it seems like there should actually be some kind of relief granted here. And she should probably be getting what she asked for. But because it's written this way, she might not. Here we go. Now the audio of the transcribed calls provide a time the call is received. For example, there's a 911 call wherein a woman is reporting a fire of a car at the same place the kids were at 2 hours. The caller can see the vehicle burning. 5th floor, totally different complex. I knew they were doing something back there. This audio is a portion of calls labeled 911 calls Solomon East Drive. This call is not identified by a time or name. The same woman is heard in another 911 audio separate and apart than the merged calls referenced above. This particular call is labeled 3631 Crestwood Lake number 10. Saw 3 young black men and earlier 2 black men. She watched 2 cars pull off and describes the black thinner boy with shorter hair with a white t-shirt. This audio is cut off mid-call at 3 men, despite showing a recording time of 4:47. Another 911 call, number 15, labeled East Mall Lake Drive, reports seeing 2 black males getting into a Chevy Malibu. She further states they already came and picked up an injured guy and left. Now the white car is back, and they trying to hide something. This call does not have a time either. Again, a 911 audio call, labeled East Mall Drive, is the same caller as the above. There are multiple callers above. And again here, she is reporting the arson of the vehicle. But as all other 911 calls, there is no way to know what time the call came in. None of the transcripts of the 911 call document the time of the 911 report either. This information is crucial because it further establishes that Demetrius O'Neill was not involved in the arson or the grand theft auto crime. Moreover, certain shell casings and firearms were discovered near the crime scene cannot be used against Mr. quotation marks O'Neill. From listening to the aforementioned calls, they are not describing an Impala, as she reports that the white Chevy Malibu keeps going back to the dumpsters. Having a definitive time of these calls would establish the timeline of the criminal episode that occurred at the Sunterra apartments. The undersigned has attempted to resolve this discovery without seeking court intervention. However, when the undersigned's question about timestamps, no resolution was reached. Fantastic. Oh, there's something funny I want to show from this. The crime scene technician is Marissa Popple. Now, some of you, if you watched the Alec Baldwin Rust trial, would remember ACST Popple. Or, misconduct, not turning over evidence. Her pants were on fire because of some statements that she made on the stand. But she was employed by the Fort Myers Police Department before she went to Mexico. And so she is the crime scene technician in this case. So we could be seeing a CST Popple, on the stand. I have no idea it's probably not going to be televised, but I thought that was interesting. I assumed I was misunderstanding something when I saw it at first. Is her name here not a copy and paste snafu? No, she was the CST. She worked for Fort Myers PD. Is this bad enough to read? I don't know. I think I might look through this one real quick. Let me just rotate this. Actually, I have an idea. I'm going to show you some reporting on the underlying incident, so you have some context of what I'm talking about here. So this is the case in question. Ooh, never mind. Nearly a decade later, Club Blue shooting suspects. Oh wait, trial. This was early this year, March of this year. It's been nearly 8 years since shooting Club Blue took 2 innocent lives from our community in 2016, so this is quite a while ago. Okay, I can make it work. 14-year-old Sharon Achilles and 18-year-old Siffin Strouder had their night all planned out. Fort Myers, Club Blue, teen night. That night turned out to be the last of their lives. They were both gunned down, caught in the middle of 2 warring gang factions. Monday, those police believe are responsible were back in the courtroom. Pre-trial hearing, the state defense told the judge there'd been a series of challenges. Basically a discovery dispute. Factual, I see. There was a co-defendant, and that person was convicted. But okay, so that's just a little bit of context. Getting kind of tired of beating up on Raven Liberty. Anybody have any questions or ideas for things to look at? I don't want to be done, but I'm not sure I want to talk about Raven Liberty anymore. I like beating a dead horse. Oh, you guys are letting me down. Okay, I'm going to share something from a case that I've been working on. I'm not officially counsel yet, but this is This is an extremely complicated case procedurally. I'm still obsessed with the missing juror. I can't talk about. Okay. So for context, you guys, I don't even know the background, but there was a case where there was a jury of 12 people, and one of them just wasn't there for like days, apparently. And nobody noticed. The juror just wasn't there. There was a missing juror. They went for days. Not noticing that a juror was missing, which, again, the jury is a pretty important part of a jury trial. It's one of the most important parts. It's in the name. But what am I supposed to say about that? Homie wasn't there. Matthew knows the case. I can't remember it. Lively, I'm not touching because I don't want to get roasted. What's this stuff about Young Thug? I'm going to do a whole stream on that. The X discourse is confusing me. The X discourse is confusing me too. The snitching discussion, like, first of all, I think the snitching discussion is stupid to begin with. But people are like messing up things that like I know a lot about, and I just have to look at it. Like, I've done multiple streams about Pee Wee Roscoe conviction and his appeal. And people are just messing up basic facts. And I love that case. And people are just ruining it on Twitter. People are just throwing around Alfred plea. They have no idea what they're talking about. Yeah, I saw that, Trikisha. Woody got into that motorcycle, or four-wheeler or motorcycle. I heard conflicting things, but it looked bad. I'm glad he's okay. I hope he stops doing, Woody things. Throwing water balloons. Driving like he drives. Just being himself. I hope he stops doing some of that stuff. Big Play Bray, explain how appeal process works. Ooh. I don't know if I'm qualified to talk about that one yet. I'm going to add that to my list, though. I'll definitely do that, but I need to research a bit. I need to prepare for that. That's actually something I've been teaching myself, like, right now. Especially in Georgia. It's kind of complicated in Georgia. Not wrong, just different. Okay, so what I'm going to do, this is an intro to a case. I'm just going to introduce you guys to a case that came to my attention. The outcomes for resentencing. Assuming he's going to be resentenced. He has to be convicted first. No, the resentencing would be, I don't know. This ranges are 5 to 20 for a RICO, and it would be 5 for the other count. But that could be probated, so it's hard to say exactly what the sentence would be. I don't know that he will be convicted again, though, assuming that the convictions are vacated. Didn't Whitaker used to work? Yeah, she did. Yeah, Whitaker's name came up in a case I was looking at recently, actually. But yeah, I think she was the head of the appeals division. But this is this is a case that came to my attention, and I think I'm gonna try to work on it. But again, it's a difficult one. just because of procedural rules, not because it's like hard to prove or anything. Why would she leave that? Wait, leave what? Oh, why would she leave the appeals division? I want to be a judge. But I think that at the end of this brief, you will understand why I am troubled by this case. And then maybe we can do some coverage after. Or in subsequent videos, but this is just like an introduction to the case. Oh, you guys can't see all this. There we go. That's better. So I think I'm going to read through this, and that'll probably be the end of the stream. But here we go. Devin Grant was arrested and charged with the offenses of malice murder, felony murder, voluntary manslaughter, and possession of a firearm during the commission of a crime. Mr. Grant was indicted on March. Okay, this is Devin Grant's. This is his appellate brief. This is his appeal after conviction. Mr. Grant was indicted on March 19, 2008. A jury trial was held on June 22nd, 24th, 25th, and 26th, 2009, in which Mr. Grant was found guilty of the offenses of malice murder and possession of a firearm during the commission. A motion for new trial and a subsequent amended motion for new trial were filed, and the hearing on the motion for new trial was held on November 5th. The court denied the defendant's motion for new trial on February 11th, and a notice of appeal has been filed pursuant to the trial court's denial of the motion for new trial. Catilius Middlebrooks was killed on December 31st, 2007, while gambling outside of the Brooklyn Homes apartment complex in Brunswick, Georgia. Brooklyn Homes South, if you're familiar with Brooklyn Homes housing projects. The police investigated the home of Devin Grant. The police looked for any type of physical evidence inside his house. The police did not find the weapon that was used or any pieces of clothing that were allegedly worn by the shooter in Mr. Grant's residence. Nathaniel Kennedy, an individual who lived in the area, stated that he saw a group of black males, 4 or 5, run off from the body immediately after the gunshot. Mr. Kennedy did not give a description that resembled Mr. Grant walking away from the scene, and he did not identify Mr. Grant. Tiffany Coleman, who lives in number 25 Brooklyn Homes, exited her home right after the gunshot. She did not see Devin Grant at the scene, and she testified that she knew Devin Grant. No witness was ever produced by the state that said they actually saw Devin Grant as the shooter. The Supreme Court has general jurisdiction. So these are the errors on appeal. Error 1. The state committed a Brady violation by not turning over the videotaped interview of Brittany Andrews and written report of Detective Roy Blackstock. They're kind of underselling that, but it's a Brady allegation. The trial court committed reversible error by clearing the courtroom of spectators during the proceedings. Number 3, the court committed reversible error by not allowing the jurors to rehear evidence upon request of the jury and not following proper procedures when receiving a request from the jury. Number 4, trial counsel rendered ineffective assistance of counsel by not making a challenge to the jury selection and not objecting to the trial court denying a defense request to charge. I don't know as to what, and by not adequately preparing for trial. This is probably what I would have been on. Number 5, insufficient evidence to sustain the conviction. So this is the most important section right here, section 1. This is the part that grabbed my attention right out the gate. Section 1. The state committed a Brady violation by not turning over the videotaped interview of Brittany Andrews in the written report of Detective Roy Blackstock. That's the lead detective. The state did not disclose evidence under Brady that was materially favorable to the defendant's defense, citing Brady versus Maryland. For those of you that don't know, Brady just says that the state has to give over exculpatory evidence to the defense. They can't, have evidence that they know exonerates the defendant and not turn it over. It is clear in this case that the interview of Brittany Garter by Roy Blackstock was materially favorable to the defendant, in a videotaped interview conducted by Roy Blackstock 1 year before Mr. Grant's trial, Ms. Gardner stated Liddell Ellis admitted to killing Middlebrooks, the deceased. So if you didn't catch that, there was a guy named Liddell Ellis who admitted to the killing that Grant was convicted of. And then Ms. Gardner, who's his girlfriend, told the detective about that confession. And it was videotaped. So they don't have a confession on video, but they have Brittany Gardner saying that Liddell Ellis admitted to the killing on video. Ms. Gardner also corroborated the fact that Ellis and Middlebrooks were gambling that night. In Mr. Grant's trial, the state introduced photographs of dice next to the deceased, which further corroborated Ms. Gardner's information. There's no dispute that he was gambling at the time. Everybody knows that. Or everybody involved in the case was aware of that. Rix McIlvaney testified at the motion for new trial that this evidence was exculpatory, and that it went directly to point of who did it. Mr. McIlvaney stated that he represented Mr. Grant for a period, and that when he was handling the case, there was hearsay evidence against Liddell Ellis. In this interview, is Liddell actually confessing or admitting, making an inculpatory admission that, and giving motive for why he would have done it. McIlvaney was then asked, do you believe that the state knew about this evidence when the Grant trial came up? And his response was yes, because it was, the interview was done a year before the Grant trial by the lead prosecutor, they call them prosecutors, lead detective, Detective Blackstock. So it'd be impossible for them not to know. And there's a video. And again, the state has everything that the detective has, so it's kind of an odd to frame it that way. The state absolutely had it. But it was the same, to be clear, it was the same lead detective in both cases. And I'm getting ahead of myself. Just remember the name Blackstock. If trial counsel had been provided this interview, it would have changed the whole case because of someone else admitting to killing the deceased. Fair enough. Since this is also newly discovered evidence, the defendant would be entitled to a new trial. I don't know, it's capitalized under 523. That's the procedure. All the requirements for a grant of new trial have been met, as shown by Turner v. State, and it has also been held that while 5523 states that a new trial may be granted, it has been held in Matthews where all rules of law have been met, new trial must be granted. The state attempted to show that the evidence was not intentionally withheld or in a different file. Therefore, there is no misconduct or Brady violation. That's fucking insane, but okay. That is not where the inquiry stops. In the case of Kyles, the court held that information known to law enforcement is imputed to the prosecutor, and therefore exculpatory information withheld by law enforcement may constitute a Brady violation. Court in Kyles also defined what materiality means by the showing of 4 different factors. A showing of materiality does not require demonstration by preponderance that disclosure of the suppressed evidence would have resulted ultimately in the defendant's acquittal. Undisclosed evidence might require a new trial, even if it is more likely than not that a jury seeing the new evidence would still convict. The defendant must show only that the government's evidentiary suppression undermines confidence. It's a low standard in the outcome of the trial. Second, a defendant need not show there is insufficient evidence to convict in view of the suppressed evidence. Third, there is no harmless error review of Brady errors. 4, materiality is to be determined collectively, not item by item. New trial should be granted because of the Brady violation by not disclosing evidence that was material to the defense. 2, we're not going to read. The judge cleared the courtroom when she shouldn't have. 3 might be even crazier than 1. This is where it gets really wild. In the case at bar, the jury sent a request to rehear witness testimony. When jurors sent a question out during deliberation, there are certain requirements that have to be met by the trial court in responding. In Lowry, the court set forth specific requirements for a trial court when a jury wants to communicate with the court during deliberations. These communications must be in writing, should be marked as a court's exhibit. Counsel should be advised of the communications, given an opportunity to suggest a response. Those requirements. The trial court did not comply with the requirements for jury communications. The requirement that the communications must be in writing may have been complied with, but there are no exhibits. The trial court actually states, now they have asked for somebody else, and so the answer is no. It's 4:15, and I'm not going to go into more. They want Scott Harrell's testimony too. I'm not doing it. I'm not opening it back up. They're just going to have to remember it, the evidence. I mean, we can piecemeal this thing until we go back over the entire trial. I'm not doing it. I don't even mind doing sometimes too, but I refuse to go back over all this stuff again. Trial court did not allow for the replay of the testimony because she stated, it's Friday afternoon, I'm not doing it. The two witnesses were Talia Thomas, who was Grant's cousin, and Matthew, yes and no. This is a disgraced judge, but it's not the one I read about. I was looking for her. So she resigned in disgrace, and I was looking for her thing when I found the other one. I did find the judicial complaint about her. NPR did an entire episode about how terrible this judge is. It was an hour long. This American Life. For those of you who don't know, the district attorney when this was going, not the trial, but the appeal process, was Jackie Johnson, who you may remember from State versus Jackie Johnson. She was the one that tried to cover up Ahmaud Arbery's killing, also in Glynn County. So the district attorney was also resigned in disgrace. The line prosecutor who tried the case is a guy named Keith Higgins, and he's the current district attorney. And the counties that he oversees are suing him to get him to stop being the district attorney because they think he misappropriated funds. So the line prosecutor is also maybe corrupt and is accused of misconduct. So essentially everybody involved is corrupt. Oh, thanks, Brooklyn. And there's more. There are more people that are corrupt. I can keep going. Ryan did. Yeah, he won that case. He probably should have won. I didn't mind the acquittal. Based on what they were charging. But as far as like her responsibilities as a prosecutor, I think she fell short. Not rising to the level of criminality, though. The court did not have the communication marked as a court exhibit. Counsel was not given a full opportunity to respond. And when the jury asked to hear the testimony of Scott Harrell, he's one of the investigators, the court gave no opportunity for a response. The trial court did not grant the jury's request, and the only specific finding the trial court enumerated was because it was late on a Friday afternoon. The trial court did not comply with any of the requirements when juries communicate during deliberations. The defendant is entitled to a new trial because of the court's noncompliance. The record shows that when the court declined to let them rehear the testimony, the jury reached a verdict 20 minutes later. The trial court stated, I'll give them 30 more minutes. They want 30 minutes. That probably did it. So she denied the rehearing of evidence, and they convicted immediately thereafter. So clearly, I mean, the inference is that they had questions about evidence, and they couldn't get an answer, and so they convicted. If that evidence wasn't favorable to the defense, then they would have just convicted. They wouldn't need to ask to see it, I assume. It was also error for the trial court to refuse the jury's request to rehear the testimony of key witnesses, citing Scroggins. While that case is distinguished because in the present case the court did not comment on the veracity of the testimony, the jury only requested the replay of the testimony of Talia Thomas and Scott Harrell, who were key witnesses in the present case. Ms. Thomas purportedly testified about Mr. Grant's role in the killing. Mr. Harrell's testimony was critical in the impeachment of a key witness for the state. Having looked at the transcript, I think both of these people were favorable for the defense. The court also seems to contradict its own assertion that it would be willing to let the jury hear the testimony of two witnesses. I don't even mind sometimes doing two, but I refuse to go back over all this stuff again, when the jury, in fact, only asked to rehear Ms. Thomas and Mr. Harrell. These witnesses were key witnesses, and the court committed error by not letting the jury rehear the testimony. Now we're going to look at this one. Trial counsel was asked about his defenses regarding the charges, and he answered, "Our defense was that he was not present there, that he knew nothing about this, and there were no witnesses that I had no names of witnesses that I thought would be beneficial to that ends." Our defense was basically trying to make the prosecution prove its case. It's not really a defense. Trial counsel did not adequately prepare for the case because a proper investigation was not done, and when asked what he did to investigate the case, his response was that other than speaking with Devin and reviewing all the discovery and getting his mother subpoenaed, there wasn't a whole lot of other investigation that was done. So none, really. Trial counsel did not adequately review the potential witnesses prior to trial. He stated that he attempted to reach some of the civilian witnesses by telephone when there were telephone numbers available, but that he did not speak to any of the police witnesses prior to trial. Should they allow juries to replay streams video in the jury room? Yeah, I think so. As long as it's like official video that the court has a copy of. I'm always in favor of the jury having more information. As long as it's, verified to be the correct information, like a video is. Trial counsel conducted virtually no investigation, and his defense strategy was to make the state prove their case. When counsel conducts virtually no investigation and fails to mount any kind of defense, it is ineffective assistance of counsel. There is insufficient evidence. I completely agree. But you're never going to win on that. Now I want to show you a little something about the judge. Oh, wait, I don't think this is the right file. Oh, it's too small. Not bad. Here we go. So, judicial qualifications, State of Georgia, inquiry concerning Judge Amanda Williams. That was the judge that we just heard about. The one who did not allow the evidence to be reheard. This is to notify you that after conducting an investigation into various complaints against you, Judicial Council has decided, or Commission, has decided to initiate formal proceedings for the purpose of determining whether you are guilty of violations of Georgia law, willful misconduct, or other conduct prejudicial to the administration of justice, which brings your judicial office into disrepute. You were first elected to judicial office in 1990. And this was 2012, I think. So during a portion of your tenure, you presided over the drug court program. The purpose of these proceedings is to determine whether you violated Canon 2, which requires that you respect and comply with the law, and act at all times in a manner that promotes public confidence in the judiciary. When you directed that Lindsay Dills be held in restrictive custody in the Glynn County Jail, you violated Canon 3, which provides that judges shall accord every person who has a legal interest in a proceeding or that person's lawyer the right to be heard. When you ordered defendant Dills into indefinite restrictive custody without affording her the right to be heard. C. Violated Canon 2A, judges shall respect and comply with the law. And 3B should be faithful to the law when you issued a restrictive order that denied Dills the right to consult with a lawyer. You violated 2A when you ordered Dills to be incarcerated indefinitely. Okay, here's the background. Lindsay Dills entered your drug court program in March of 2005 after entering a guilty plea for forging 2 of her parents' checks. The court records showed that she had a history of attempting suicide. Despite her history, on or about October 8th, you held in chambers and outside the presence of the public and a court reporter a hearing at which you sanctioned Dills to 28 days in custody for violation of her drug court contract. However, on or about October 8th, after Dills was taken into custody and transported to jail, you sua sponte, that means on your own, modified her 28-day sentence to a period of confinement indefinitely in the Glynn County Jail and until further order of the court. That is not a thing. Can't have an indefinite sentence in any context. Furthermore, on or about October 8th, after Dills had been sentenced and transported to jail, and you returned to the courtroom and gave verbal directives to personnel and or court officers to wit, on Lindsay Dills, she is not to have any telephone privileges, and no one is to contact her or visit her except Gail Kelly. She was the drug court program. Nobody, total restriction. Contrary to your repeated representations that the sheriff of Glynn County or the drug treatment team made the decision to hold Dills in isolation, you personally issued the directive to wit, per Major Thomas, per Judge Williams, inmate Lindsay Dills to have no contact with anyone while she is incarcerated. No mail, no phone calls, no visitors. The only person she can talk to and or visit is drug court counselor Gail Kelly. No one, including either Dills' drug counselor or her attorney, visited her during the confinement period. Dills remained in custody for approximately 73 days. On or about December 9th, Dills attempted suicide while in solitary and restrictive confinement. After the suicide attempt, Dills remained on court-ordered lockdown until about December 22nd, 2008, when she was subsequently transferred to an inpatient treatment facility. The time you ordered Dills into indefinite restricted custody, you knew or should have known that Dills was predisposed to suicidal tendencies, having previously signed an order placing her on a suicide watch. When queried, you and or your legal counsel on your behalf knowingly denied that you ordered any defendant at any time to be held in restricted custody, solitary confinement, or otherwise directed the conditions by which an inmate should be housed. When drug court personnel, you have indefinitely incarcerated defendants for drug court violations. Count 2. You violated Canon 2 by your practice of holding drug court participants indefinitely without a hearing and instituting a policy delaying their placement into treatment. You violated Canon 2A when you sanctioned drug court participant Charlie McCullough for exercising his right to contest the results of a drug screen. You violated 2B when you allowed social, political, or other relationships to influence your judicial conduct or judgment. You violated 2A when you failed to comply with the law and acted in a manner that promotes public confidence in the judiciary by ordering Eliza Branch to be confined to a treatment facility on total restriction. Thank you, Takesha. Charles Cunningham entered drug court on or about May 14, 2008. He thereafter absconded. You issued a bench warrant on or about August 27, 2008, and Cunningham was arrested. He was not released until the summer of 2010. The May 12, 2010 official report to court notice states the following with regard to Cunningham. Failure to report sit-in placement under recommendations is written summertime. Cunningham's case manager sought to have the defendant transferred to a treatment program. When the case manager requested that the court release Cunningham, you indicated that you were not ready to deal with him and that Cunningham would have to wait until summer. Cunningham was not released and transferred into the treatment program until around July 12, 2010, when you ordered that he remain there until the completion of the program. Okay, now we're getting into trouble. Charlie McCullough was 3 months away from graduating from the Glynn County Drug Court program. After 22 months in the program, he was subjected to a random drug screening and tested positive for the presence of an illegal substance. McCullough requested and took another test approximately 20 minutes later. That result was negative for the presence of an illegal substance. A third test produced the same negative result, so it looks like a false positive on the first test, and 2 subsequent tests confirmed the false positive. the drug counselor advised McCullough that he would be required to appear in court because of the result of the first drug test. Although he passed both the second and third tests, the counselor informed McCullough that you, the judge, would only use the first test in determining his sanction. When McCullough appeared before you and attempted to explain the false positive, a colloquy took place between you and him, to wit, McCullough says, "May I speak?" "Yes." "I have no explanation for that at all. I don't. 20 minutes later, I took another test. It was tested 3 times. I passed that. Okay, I can't explain to you why. All I know is what I've done and what I haven't done." Judge, "Well, I don't believe you." McCullough, "I'm not going to go 22 months with clean time and then 3 months from my graduation, use drugs." Williams, "Well, people have done it." Consequently, you sentenced McCullough to 17 days in jail. Court records show the 17 days is comprised of 2 sanctions, only 3 for having a positive drug test and 14 for disputing the initial screen, even though his dispute was correct. On or about August 21st, 2008, the grandfather of Eliza Branch filed an application for an arrest warrant of Branch for 1 count of forgery and 1 count of fraud. Her grandparents filed a complaint for temporary custody for immediate custody of her 2 kids. You signed the ex parte order awarding temporary custody of the children to Branch's grandparents on or about August 22nd, 2008. No hearing was held on the ex parte motion or your temporary order awarding custody to Branch's grandparents. On or about August 27th, you released Branch on an own recognizance bond subject to the special condition that she complete the Bridges of Hope treatment program. Branch failed to comply with the conditions, didn't complete the program, was taken into custody on December 29th. On about January 9th, you released her on another bond, required that she live at the home of her grandparents. That January, she appeared represented by a public defender and signed a drug court contract. She entered the program by pleading guilty to 2 non-drug related criminal offenses. Another warrant issued in March. Branch was held in Glynn County until May 2009, when she was released on an order for house arrest with electronic monitoring. She continued in the program but failed to appear for drug court on November 18th, and a bench warrant was again issued. Incarcerated for 157 days. On June 9th, you issued an order releasing her into the custody of her grandfather, who transported her again to Bridges of Hope, where she was ordered to reside for a period of 12 months. You further directed that Branch have no visitation or contact with any outside persons. This deprived Branch of her right to confer with counsel. Okay, I can do a little bit more. Sorry to lose my voice. You violated 3B when you engaged in ex parte communications about substantive legal matters. Attorney Robert Morgan filed a complaint for modification of child support in the case of Horn v. Horn on behalf of the husband. While this domestic matter was pending, Ms. Horn, the former wife, was participating as a defendant in the drug court program and was represented by the public defender. April 28th, Ms. Horn appeared in drug court. After representing Ms. Horn in the criminal case, the public defender consulted with her about the pending domestic case. Without consulting with opposing counsel, the public defender presented to you a motion to consolidate the drug court case in the civil domestic matter. I have no idea how that's possible. Pursuant to this ex parte meeting, and without a showing of any necessity, you signed an order granting Ms. Horn's motion to consolidate. When Attorney Morgan learned of it, he requested a conference with the judge and the PD. At this meeting, Attorney Morgan objected to your consolidation of the criminal and civil cases. In response, you told Attorney Morgan, "I do not give a shit who hears these cases." In response, Attorney Morgan presented you 2 orders for voluntary recusal. You refused to sign the orders and began yelling and cursing at Morgan. You initially refused to recuse yourself, then improperly assigned the cases to another judge that you selected. You violated Can 3C, which provides that judges shall avoid nepotism and exercise the power of appointment impartially when you appointed your daughter as a guardian ad litem. Failed to allow all parties to be heard on a custody matter. Allowed her family relationships to influence her conduct. Failed to recuse herself. Failed to recuse herself. Presided over a case in which you were disqualified, in which you had previously reassigned to another judge. You violated Canon 3E when you, having been disqualified, heard matters on an alleged emergency basis under the rule of necessity, when there's no emergency. You allowed your tenant, also the then law partner of your son, to appear before you on numerous occasions. In the case of Walden v. Garner, case involving custody, you heard a matter involving temporary custody. The parents both appeared pro se. The great-grandmother, as intervener, was represented by counsel. Also present in the courtroom was your daughter, Attorney Frances Williams Dial. You asked your daughter, Frances, come forward, go talk to these people about the children. Daughter, the father, Attorney Dial, the father, and Garner left the courtroom to discuss. Garner's counsel remained in the courtroom, and the mother was instructed to wait in the outer hallway. After a short period, Attorney Dial, the father, and Garner returned to the courtroom, and along with Garner's counsel, approached the bench. Attorney Dial, acting as the appointed guardian ad litem, recommended to you that temporary custody be given to Garner. You accepted your daughter's recommendation and instructed Garner's counsel to prepare an order. The mother had no opportunity to be heard on, challenge, participate in, or cross-examine Attorney Dial's findings. You failed to allow all parties to be heard prior to accepting your daughter's recommendation. Attorney Dial was operating under no written appointment as a guardian ad litem. There was no disclosure on the record or otherwise to any party regarding your familial relationship with Attorney Dial. In another case, Joseph v. Joseph, you appointed Attorney Dial as guardian ad litem. You contended that the attorneys handling this matter insisted on this appointment because Attorney Dial was the only lawyer available with the expertise to take care of the issues related to the children. Moreover, in the Joseph case, you failed to make a record of any alleged waiver, and you further failed to advise the parties of this conflict. Mr. Joseph contends that he would never advise of the conflict, and that if he had known, he would not have consented to the appointment. Also in the Joseph case, you ordered that the parties pay your daughter $1,000 within 30 days, failing which the parties would be subject to contempt of court. Yeah, that's right, wife. She says, usually a judge picks guardian for the child to avoid the situation. Yeah. Somebody who's looking out for the child, in theory. Crabb, you signed a temporary consent order prepared by your daughter. The pleadings were signed by both your husband, James Williams, and daughter as attorneys for the defendant. You explained your involvement in this case, saying that the order presented to you was agreed to by all parties. However, there's no known record of any said notice of conflict to the parties or counsel as required. On March 24th, Attorney Dial wrote a letter to the Glynn County Clerk requesting that the Crabb case be scheduled before you on April 8th. You, however, failed to timely disqualify and recuse yourself. Rather, you allowed this case to remain in your docket until around January 6th, 2009, when you reassigned the matter. Following the case, there are other instances where your family members were involved in litigation and you improperly ordered reassignment to judges you selected. So again, it's supposed to be random, or the chief judge is supposed to pick the reassignment so that you can't, funnel it to somebody else that you think would be favorable. So do judges have continuing training or professional development? I think the good ones do. I don't know if it's required, though. They get their position and that's it. It's not life on the bench, it's elected. But yeah. Lindsay versus Lindy, your son appeared, reassigned to Roundtree. Not Caldwell here, but all but one were assigned to Judge Roundtree. So clearly she thinks that that's a favorable judge. Additionally, you heard several cases where you've been disqualified when you heard matters on an emergency basis. Falligan, let me see. Family Violence 12-month protective order was filed on December 11, 2007 by your daughter. You entered an ex parte order directing the respondent to appear on January 8th in another judge's court. You then improperly reassigned the case to Judge Scarlett. In spite of this reassignment, on or about January 8th, you presided over this matter and signed an order prepared by Attorney Dial. McDonough, a temporary restraining order was presented to you by your daughter-in-law. This order was signed by you on or about November 30th, 2009. You failed to disclose on the record the basis for the disqualification. Attorney Jason Clark, while the law partner of your son, Nathan Williams, regularly appeared before you in both contested and uncontested matters. Attorney Clark was then not only a law partner of your son, but he also was a tenant who paid monthly rent to you. As such, you, as his landlord, had a financial interest bias in his successful law practice. You contend that your son's law partner appeared in drug court as a result of a waiver signed by the DA, although this in 2007, although the waiver is dated and signed in 2010. There's no waiver signed prior to this time when Attorney Clark was nevertheless appearing before you in court. You violated Candy 7 when you endorsed Jackie Johnson for the office of District Attorney. Womp womp. At a reception held at your home, you announced to a group of women lawyers that it was time for the circuit to have a female DA and that you were supporting Jackie Johnson, a female ADA, to replace Stephen Kelly in anticipation of a vacancy. That didn't end well. Since this time, you have denied and qualified this endorsement. You showed favoritism, personal bias, This is more procedural stuff, but let me see this. Furthermore, you continue to improperly act ex parte in proceedings where the respondents were denied the opportunity to be heard by the court or given due process. To wit, in the domestic relations contempt action brought by Henry Bishop against his former wife, resulting in an illegal lockup order against Lisa Bishop. You allowed your social or employment relationships with your bailiff to influence your conduct or judgment. You failed to disqualify yourself in a case involving your bailiff's son, having a personal bias concerning his family, such that your impartiality might be questioned. You failed to disclose your basis for hearing the matter. Sometime in February 2010, a woman applied for a warrant for the arrest of her former husband, Jay Kaufman, based on accusations of aggravated stalking. Jay Kaufman is the son of Patricia Kaufman, your bailiff and friend. Pursuant to the warrant, Jay Kaufman was arrested on or about February 12, 2010. At the time of his felony arrest, a civil domestic relations case was pending between Jay Kaufman and his former wife, who was represented by counsel. There was a history of domestic violence. You failed to disqualify yourself from hearing this matter involving the son of your bailiff. When you became aware of Kaufman's arrest, you arranged a meeting between you, the district attorney, and the former wife's attorney. You agreed to give Kaufman a bond immediately. Furthermore, despite your obligation to disqualify yourself, you nonetheless heard the criminal bond issue without either demonstrating or articulating an emergency. You showed bias in drug court. In court, you told Bird that she could either choose to contest the charges and go to trial or enter the drug court program. If she chose drug court, she could be released on a bond. Furthermore, you advised that if she wanted a trial, she would be given a bond of $15,000, the standard for defendants who elect not to enter drug court. Further advised Bird that if she went to trial and was convicted, you would sentence her to a year in the detention center plus 4 years of probation. You advised her that was the minimum sentence she would receive. When Bird asked you about the detention center, you explained that it was a lockdown center or boot camp. Bird was wrongfully persuaded by a colloquy on the consequences of her decision to either enter the drug court program or withstand her chances of being convicted. As a result, she opted to enter the program. When Bird failed to complete the program, she attempted to withdraw her pre-adjudicated guilty plea during her termination hearing. To wit, the court, I'm going to deny her right to withdraw her plea. Are you ready to go to the termination hearing? Yes, Your Honor. Okay, who is going to comment about Ms. Bird? Can we be seated? Yes, sir. I'm sorry. Yes, you may. In the meantime, Mr. Crow, if you appeal this case, I'll tell the state to get ready. If she comes back and the case is undone, get her ready to try. That I will. I will take no pleas from her. We'll have a jury trial. Your threat and state of refusal to take any pleas from Bird should she exercise the right to appeal her conviction effectively chill the right to contest her ruling. You have used rude, abusive, or insulting language. Examples include, but are not limited to, the incident In or about 2010, a group of juvenile probationers appeared in the drug court to observe drug court proceedings. You acknowledged the group of young girls and boys, telling them about the dangers of drug abuse. One of the participants chuckled during court, at which time he began screaming at her and ordered your bailiff to remove the juvenile, who was crying, from the courtroom in handcuffs. Later, while still in handcuffs, the juvenile was brought back before you. You admonished the juvenile about inappropriate courtroom behavior and then ordered her removed from the courtroom again to be sent to meet with the public defender. When the juvenile was returned to the courtroom, you ordered that she be released from custody. Drug court defendant appeared before you to request to be excused from a Saturday class for a family function. Because of your disdain for the young man's use of the term baby mama, you ordered that the defendant be summarily jailed. You've often appeared frustrated with drug court defendants who wish to address the court, gesturing with your hand and saying, "Don't talk to me." Any further attempt by the defendant to speak would often result in you directing the bailiff to take them into custody. When the bailiff inquired about the duration of detention, you often replied that you did not know and or make it indefinite. I don't know. I think that was more recent Kerr now. That's probably a different one. Okay, count 11. Prohibits her from using tyrannical partiality in the administration or under the color of your office. She has made material false statements during the investigation. Another violation. So yeah. She eventually resigned to which ended this proceeding. So she wasn't like formally convicted or anything. But she resigned and this was closed. But she's the judge that was involved in this case here that we went over earlier. She's the one who decided not to hear the thing on the Friday afternoon. I'm not doing it. I think this was in 2009. Yeah, June 2009. So this was right around the same time that she was doing all the other bad stuff. That's in addition to the other corrupt people involved in the case. But the defendant is still serving a life sentence. And there's more stuff. I mean, this case is ridiculous. Hoping we can do something about it. But okay, I'm losing my voice, so I think I'm going to wrap it up. Thanks for listening. Thanks for coming. Let me rant about random things. My little therapy. But I'm going to call it a night. And yeah, thanks for coming, everybody. And I'll see you next time.